really important to have a plan and understand what your goals are.
In fact, my camel out there is suffering right now with a broken back.
So I actually found Pepe when it was only a couple of hours old, and I'm like, oh, this is a funny meme.
Oh my god.
Yo! Who is this Degen?
The old man is swing trading over years at a time. And it's like, that's where the real money is made.
The answer is a permanent loss. With single-sided staking, you don't have to worry about impermanent loss.
Really, at the end of the day, it's just the matter of a macro market. It's just what happens.
If you're aware, if you're disciplined, you can hone that into further financial growth.
Financial freedom, so we can actually live life and not have to be constantly living paycheck to paycheck. I mean, that's the ultimate goal, more or less, right?
Ladies and gentlemen, boys and girls, crypto degenerates, ducks and squirrels, welcome to episode Book Club, Degen Roundtable Book Club, episode number 99, the great almost centennial episode. Tonight we're going to be reading live the treatise on the word person by Brandon Joe Williams. It's going to be an interesting show. I've been meaning to read this document for a long time, and I've been putting it off, and so I figured I might as well do it live. So, since I am an ambassador for the nation of the Amnesty Coalition, it is required to have read the treatise of the word person. And so that's what I'm going to be doing. That's what's going to be happening tonight for the show. And I don't blame you guys if you drop out at any point in time, because it's going to probably be a long one. I'll go ahead and pull up the document for the show so you guys can see just how long this document is. But here is the Brandon Joe Williams treatise on a word person. If you look at that little scrolly wheel, just exactly how long this doco is. If we were to put it in a let's see, if we put it in oh goodness, wow, would you look at that? Hang on a second. I'm gonna do I'm gonna switch up the way that we share the screen. The point is, it's a long fucking document. It's a big document, and so whoa, wrong camera setup. There we go. It's a long document, so it's gonna be a big one. Excuse me. It's going to be a good one, and it's going to be quite fantastic. So that's what we are doing tonight, ladies and germs. We're doing a live reading for you. We're not doing the Ludwig von Mises Theory of Money and Credit. That one is going to be happening next week, I believe. We keep postponing it, and it's just, that's the way she goes. So in lieu of not doing that, I'm going to read to you guys this fantastic treatise on the word person. And basically the TLDR of it is the word person doesn't mean exactly what you think it means. It means a whole bunch of things. In the Constitution, which is a common law document, it says "we the people." And there's a couple times in the Law of Nations by Vattel where he delineates the difference, or where he talks about people and where he talks about persons. And what is the difference between the two of them? And technically, like, there's a whole bunch of things that count as persons, and it's not just like meaty flesh sacks that walk around and exit, like, occupy space and time as a human being. So excuse me. So that's what we're going to be covering. That's what we're going to be doing tonight. I guess before we do any of that stuff, we should do the chat motherfucking shoutouts. Where is my binder? There is my binder, my chat shoutouts binder. The handy dandy, my chat shoutouts document is not inside my chat shoutouts binder. This is a travesty. Aha, here it is. It's hiding on my desk, just out of sight. Ugh, okay, there we go. Ladies and germs, it's time for the chat motherfucking shoutouts. Best part of the show. Everyone's favorite part of the show. Nobody likes hearing me talk. You guys like hearing yourself talk. And so for that, we've got Mr. Slide 180, my good homie Josh from the Marine Corps. What's up, broski? Good to see you. He is saying cheers to us. We're going to have a very cheersing night tonight, guys. If you guys have any thoughts, by the way, of this incredibly long document as I'm sitting here and reading it, please do not hesitate to share your thoughts with me in the comments. I will be periodically checking the comments to, oh my goodness, my phone is playing music. Would you look at that? All right. I need to plug my phone into the charger and set it up over to the side, so that way we have documentation. And I guess we'll just hop right on into it. So let me go ahead and again pull up the share screen, but we're going to do an entire window. We're going to pull up this window right here. Does that look cleaner? I think that might look cleaner. Let me see. We'll switch the camera side to that, and then we will change the background to a whole lot of nothingness. There we go. All right, so treatise on the word person. So we have this as an option, and we can also close out reading mode. We could just have the entire treatise right here. Man, this is going to take a while, guys. So hold on to your hats, because we're fucking going for it. We're going to talk about the slaughterhouse cases. We're going to talk about like domicile. We're going to talk about residence. We're going to talk about US v. Khrushchev, Madden v. Commissioner, Jones v. Terrier. This is a whole bunch of case law that's referenced here, and a whole bunch of other such things. So this is all of the stuff that we're going to be covering. Also, Susan B. Anthony. This is a very good one. For those of you guys that don't know, Susan B. Anthony was the lady that wanted to vote, and she was like, "Oh, well, now that the 14th citizen has been invented, I'm a 14th citizen. I'm a 14th Amendment citizen." But it's like, no, actually, you're not, because you're a free white person. And the 14th Amendment was created for the slaves that were being the Negro slaves that were being released after the shoot, the freeing of the slaves post Civil War. So let's see. Expanding the word persons to include artificial fictions. Oh yeah, and then so after the slaughterhouse cases, like persons, like a corporation is a person. So like corporations are persons as well, which is quite fantastic. Yeah, so 14th Amendment. Yeah. So we're going to be covering all of this, and we're going to see just exactly how long it takes me to read this. I have a feeling it's going to take a incredibly long time. Man, my goodness. Oh, look at that. There's a whole bunch of Code of Federal Regulations. Yeah, a whole bunch of stuff. And we're not even halfway through it yet. So hold on to your butts, guys. We're going through this. And by the way, all of this information can be found at williamsandwilliamslawfirm.com, which is Brandon Joe Williams Law Group. So if you guys wish to check any of this stuff out, you just go to A Treatise on the Word Person underneath Williams and Williams Law Group, or, williamsandwilliams.com. Excuse me. williamsandwilliamslawfirm.com /A Treatise on the Word Person. So without any further ado, enough dilly-dallying, guys. It's time for me to actually read this damn thing. A Treatise on the Word Person. Originally started this writing as of the 4th of June, 2025. Or excuse me, not the 4th of June. 4/6 would be the 6th of March. Something like that. Or the 6th of April. Who the fuck knows? There you go. This is the date when it first started. Originally started writing this a couple years ago. It was last updated 7/9/26. So that was yesterday. It was when this document was last updated. Important note. My 3.0 free contract killer course covers the entire treatise and also the flowchart in vast detail in the first and second videos. I recommend you sign up for that and also read this, as things may be added as time progresses after the course. Important note number 2, you can find the flowchart that has key aspects of this page all boiled down into one chart. There is also a poster available for sale. This flowchart should be something that you put up in your home and look at constantly every day, because it will be something you want to memorize. The flowchart is called Flowchart Constitutional versus 14th Amendment Protections and Obligations, and you can find the newest version available on this page, theamnestycoalition.org, resources and documents. So we're actually going to go and take a look at that before we read the treatise on the word person itself. We're going to take a look at the, where is it? Merch store, explanatory statement, cover letter, authorization for campus, trust templates. Where is, okay, there's UCC 3 flowchart, and then here is constitutional versus 14th Amendment protections and obligations. So this is quite fascinating. So here's the link to the flowchart. Let's take a look at it. Watch my computer just get hella viruses right now. So this flowchart is much simpler than the entire treatise that we're about to read. So Wow, that's a lame way to do the zoom. We're going to zoom fit to width. Oh, are you kidding me? We're going to decline the cookies. We don't want no cookies. Fit to width. What the heck? All right, whatever. You know what, guys? We're not going to look at it. If you want to look at it, you know where to find it. You go to that website and you take a fucking look. So there she is. Introduction. A treatise means a written work dealing formally and systematically with a subject. Since I started my adventure into the study of law in September 2021, the word person has always been the crux of most confusions, difficulties, upsets, etc. There is literally endless confusion as regards to this word, and it is the single word that has caused a complete breakdown and destruction of our glorious country of America. After over 3 years of heavy research into various areas of law, here in April of 2025, due to some massive recent breakthroughs in research, we now have enough information to map the entire breakdown of and loss of original knowledge of the most important word in all existence. A word that 99.9% of people don't even realize is literally one of the biggest issues in our entire culture and in all other cultures around the world. We're going to do some zooming in, see if that helps. Ooh, that does help. I like it. All around the world. As of April 2025, this page is the most important piece that I have ever written of anything in my entire line of research and will completely transform the life of anyone who takes the time to understand it and realize the implications that it has on their life. This page will attempt to walk through the entire timeline of the word person, the word persons, the word people, etc. For newcomers, this may sound ridiculous or strange, but I assure you that it is not. In today's world, the term person is so far gone and so far beyond confusion that it is in a state of complete oblivion. The definition of oblivion is the state of being unaware or unconscious of what is happening. No one is even aware that this word does not even mean anything even remotely close to any assumptions that they may have on the subject. Part 2, the original definition of citizen and people. Section 1 of the Naturalization Act of 1790 is where our journey begins with a text that reads, "Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that any alien, being a free white person, who shall have resided within the limits and under the jurisdiction of the United States for the term of 2 years, may be admitted to become a citizen thereof, on application to any common law court of record, in any one of the states wherein he shall have resided for the term of 1 year at least, and making proof to the satisfaction of such court that he is a person of good character, and taking the oath or affirmation prescribed by law to support the Constitution of the United States." For those of you that are new to my research, the term resident is quite important in the above quote because it is significantly used in reference to aliens prior to their 2 years being complete. Resident means foreigner or immigrant, which is why people are residents during their 2-year period while naturalizing. The term alien is defined in 8 U.S. Code, subsection 1101A3 as the term alien means any person not a citizen or national of the United States. 1790 was the first version of the Naturalization Act, but 1802 was the last updated version and the version that is currently active. So, what were the initial points that needed to be met in order to gain citizenship in the United States, if not born in a state of the Union? Well, let's break down the above quote by specific point. Was previously an alien, meaning non-citizen or non-national. 2, meets the criteria of being a free white person. 3, has resided, meaning they are not a citizen of the state yet, in the U.S. for 5 years as an immigrant, with 1 year in the state of application. It was originally 2 years residence, but they extended it to 5 in later updated acts. 4, demonstrates good moral character and swears an oath to support the U.S. Constitution. 5, relinquishes all other allegiances or citizenships worldwide. Now, it's important to keep in mind that there was only state citizenship at the time, and the term U.S. citizen or United States citizen was not a specific and separated type of citizenship at this time, and it wasn't until 1868. So the above description is how some people would become a citizen of a state of the Union. We'll cover more about that later, and it might be best to read through this page 2 or 3 times to make sure that you understand the entire timeline. So, what is the definition of a free white person? Let's look in Black's Law 4th edition to figure that out. 1. Meaning all persons belonging to the European races then commonly counted as white, and their descendants, including such descendants in other countries to which they have emigrated. It includes all European Jews, more or less intermixed with peoples of Celtic, Scandinavian, Teutonic, Iberian, Latin, Greek, and Slavic descent. It includes Magyars, Lapps, and Finns, and the Basques and Albanians. It includes the mixed Latin, Celtic, Iberian, and Moorish inhabitants of Spain and Portugal, the mixed Greek, Latin, Phoenician, and North African inhabitants of Sicily, and the mixed Slav and Tartar inhabitants of South Russia. It does not mean Caucasian race, Aryan race, or Indo-European races, nor the mixed Indo-European, Dravidian, Semitic, and Mongolian peoples who inhabit Persia. A Syrian of Asiatic birth and descent will not be entitled to become a naturalized citizen of the United States as being a free white person. And this is ex parte Sadid. And I'm not going to read all of this citation, but that's where all of this stuff comes from. Nor a native-born Filipino, U.S. v. Javier, nor a native of India who belonged to Hindu race. Chewy, Brendan, that's quite specific. Yes, you are correct. It's not just the color of someone's skin, it was laser precise. The way that naturalization works is very simple. There is essentially a period of almost like proving yourself, kind of like when someone, and again, guys, remember, this isn't Brendan Joe Williams' opinion. This is literally the United States Code as it was written. The way naturalization works is very simple. There is essentially a period of almost like proving yourself, kind of like when someone rushes a fraternity or sorority in college, or maybe needs to work to make new friends when they move to a new job or school. This transition period could be considered a period of naturalization, where you are a resident of the new zone until you fully assimilate, and then your status changes from resident to a citizen. We're going to talk much more about this as we progress into this treatise, so if it doesn't make sense yet, don't worry. 3. The introduction of the term persons. Originally found in Article 1, Section 9, Clause 1 of our Constitution, the Slave Trade Clause, we see this term persons used to describe colored persons of African blood. This distinction between we the people and a persons is sharply described in Dred Scott v. Oh, goodness. I just clicked it. In Dred Scott v. Sanford, 60 U.S. 393 U.S. Supreme Court, 1857. So if you guys are familiar with the Dred Scott case, that's where the term persons and people is sharply described. In this case, which is regarded as a released slave attempting to gain citizenship of a state, we have the following quotes from the then Chief Justice of the United States Supreme Court, the Honorable Roger Brooke Taney. Bold words and underlines added to bring specific attention to specific words. The words people of the United States and citizens are synonymous terms and mean the same thing. They both describe the political body who, according to our Republican institutions, form the sovereignty, and who hold power and conduct the government through their representatives. They are what we familiarly call the sovereign people, and every citizen is one of the people, and is a constituent member of this sovereignty. The question before us is whether the class of persons described in the plea and abatement compose a portion of this people and are constituent members of the sovereignty. We think they are not, and that they are not included, and were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. On the contrary, they were at the time considered as a subordinate, and this is Roger B. Taney referring to when the Constitution was written. Not whether it's right or wrong, but just what was being written at the time. So back to the document. On the contrary, they were at that time then considered as a subordinate and inferior class of beings who had been subjugated by the dominant race, and, whether emancipated or not, yet remained subject to their authority, and had no rights or privileges but such as those who held the power and the government might choose to grant them. 3. In the opinion of the court, the legislation and histories of the times and the language used in the Declaration of Independence show that neither the class of persons who had been imported as slaves nor their descendants, whether they had become free or not, were then acknowledged as part of the people, nor intended to be included in the general words used in that memorable instrument. It is difficult at this day to realize the state of public opinion in relation to that unfortunate race which prevailed in the civilized and enlightened portions of the world at the time of the Declaration of Independence and when the Constitution of the United States was framed and adopted. But the public history of every European nation displays it in a manner too plain to be mistaken. They had for more than a century before been regarded as beings of an inferior order and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit. He was bought and sold and treated as an ordinary article of merchandise and traffic whenever a profit could be made by it. This opinion was at the time fixed and universal in the civilized portion of the white race. It was regarded as an axiom in morals as well as in politics, which no one thought of disputing, nor supposed to be open to dispute. And men in every grade and position in society daily and habitually acted upon it in their private pursuits as well as in matters of public concern, without doubting for a moment the correctness of this opinion. And in no nation was this opinion more firmly fixed or more uniformly acted upon than by the English government and the English people. They not only seized them on the coast of Africa and sold them or held them in slavery for their own use, but they took them as ordinary articles of merchandise to every country where they could make a profit on them, and were far more extensively engaged in this commerce than any other nation in the world. But there are two clauses in the Constitution which point directly and specifically to the Negro race as a separate class of persons, and to show clarity that they were not regarded as a portion of the people or citizens of the government then formed. So these are three quotes from Roger B. Taney, who, by the way, guys, in case you didn't know, he dedicated his life to like freeing slaves and freeing the black people and helping them obtain rights as persons within the United States. And things like that. So just so you guys know a little bit of background on this guy, he wasn't like some crazy racist or anything. He was reading the document and describing the document of the Constitution. So give me a second. We're going to do a quick round of the chats. We're going to give some shout out to Mr. Moonpilled Rational Optics. Good to see you, broski. Welcome to the show. I'm just doing a live reading tonight, so if you have any thoughts or have any opinions on any of this stuff that I am covering, please do not hesitate to ask. And I have to figure out where am I in my frame, because I just realized I'm not where I thought I was. All right. Cool. Back to the document. Good to see you, Moonpill. Welcome, Joe. All right. Carefully read the above quotes over and over, taking the time to clear up any words and terms you don't fully understand. Just take a moment. These 4 quotes will completely change your life when you take the time to realize that they are talking about entirely different classes when they say people versus when they say persons. Prior to Mr. Taney's specific and clear separation of who are people from the preamble and who are persons, these terms are mostly interchangeable. Even stretching all the way back to Law of Nations by Vattel, you see an interchangeable usage between persons and people and peoples. Chief Justice Taney had been, by this case, the Chief Justice for 21 years. He and 6 of his 8 associate justices all voted for the final opinion on this case. Only 2 justices dissented of the 9 total possible votes on this case. So this was strong and positive law immediately when the final opinion was published on March 6, 1857. The case was originally argued in February of 1856, but due to the important nature of the case, it was re-argued in December of 1856. These 2 terms were the law when the original Civil Rights Act of 1866 was written to protect the Negroes. You can see how obvious this is in the opening passage of the Civil Rights Act of 1866, which I will underline in bold key points that your attention should be pointed to. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States, and such citizens of every race and color, without regard to any previous condition of slavery or involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall have the same right in every state and territory in the United States to make and enforce contracts, to sue, be parties, and give evidence to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefits of all laws and proceedings for the security of person and property as is enjoyed by white citizens, and shall be subject to like punishments, pains, and penalties, and to none other any law, statute, ordinance, regulation, or custom to the contrary notwithstanding. So basically, persons get the same of this gigantic list as is enjoyed by white citizens. So persons being separate from white citizens. So it is obvious from the above language that there is a distinct difference between being pointed out between persons and white citizens. The white citizens are the citizens that Mr. Taney was talking about in quote number 1 above, where he is talking about how they are members of the sovereignty. These white citizens are citizens of their respective states, and they are actual sovereign citizens of our nation, as defined by Chief Justice Taney. I thought that the term sovereign citizen was a hit piece term for such a long time, but I was wrong. It is a beautiful term that is used to describe the original white citizens of the states, and this definition given by Mr. Taney is still active even today, or even to today. And also, guys, free white, in today's world, like a black dude can argue that he is a free white citizen, and like none of the courts will strike it down. It's super awesome. Like like basically anybody can claim that they're a free white person, or a free white citizen. So like, just so you know, that is totally a thing that can be done. And that's something we'll probably cover later on. Then at the 39th Congress, a radical Republican named Thaddeus Stevens introduced the 14th Amendment. The entire reasoning for the amendment was to attempt to make the Civil Rights Act of 1866 something much more difficult to repeal, as seen in by these quotes by him. Some answer, your Civil Rights Bill secures the same things. That is partially true, but a law is repealable by a majority, and I need hardly say that the first time that the South, with their Copperhead allies, obtained the command of Congress, it will be repealed. The veto of the president and their votes on the bill are conclusive evidence of that. And yet I am amazed and alarmed at the impatience of certain well-meaning Republicans at the exclusion of the rebel states until the Constitution shall be so amended as to restrain their despotic desires. This amendment, once adopted, cannot be annulled without 2/3 of Congress. That they will hardly get. So basically what he's saying is like, look, guys, the Civil Rights Bill is cool, but until we make it an amendment to the Constitution, like the next Congress, if they get a majority in the South, they can just repeal it, and then the president can veto it. And it's like, what's the point of making a bill if it can be undone? We need to make it an amendment to the Constitution. So that's essentially what Thaddeus Stevens was saying. The first section prohibits the states from abridging the privileges and immunities of citizens of the United States, or lawfully depriving them of life, liberty, or property, or of denying to any person within their jurisdiction the equal protection of the laws. This amendment supplies that defect and allows Congress to correct this unjust legislation of the states, so far that the law, which operates upon one man, shall operate equally upon all. You can see from the above quotes what was going on. Mr. Taney and a vast majority of his Supreme Court made a clear line in the sand as to who were people, white citizens of a state, and who were persons, Negroes unable to be citizens. The Civil Rights Act of 1866 used that same terminology when it was referring to persons, and then that act became the 14th Amendment. So you can clearly see that the definition of persons in the 14th Amendment would be the same as the one from Dred Scott v. Sanford case and the Civil Rights Act of 1866. The first section of the 14th Amendment reads as follows, and you guys might remember this from when we did the Degen Roundtable 14 or amendment, the reading of the Bill of Rights, or not the Bill of Rights, the Constitution. So the 14th Amendment reads as follows: all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. You can clearly see that the 14th Amendment only applied to persons, not people, which makes perfect sense because people were already citizens prior to the 14th Amendment. The whites were already citizens, and it was only the Negroes that needed the special citizenship class offered by the 14th Amendment, which is called the U.S. citizen class or citizen of the United States. Occasionally, you will also see this class referred in cases such as national citizenship. So remember, guys, citizen of the United States or U.S. citizen is a 14th Amendment class that was created as a result of the 14th Amendment being ratified in order that the freed white or the freed Negro slaves were able to then gain a citizenship status separate from the state citizenship status that was like what was originally intended for the free white people that like did the rebellion project against Britain in the United States, like in the America place originally. So you had state citizens that already existed, which was the free white people from the original part of the Constitution. And then you had the 14th Amendment that was created that made the class of U.S. citizen or citizen of the United States. So that was a separate citizenship than state citizenship. So just remember that. Occasionally, you will see this class referenced in cases such as national citizenship. So while it is widely known that the 14th Amendment overturned the Dred Scott decision, it only overturned the operative aspect of how Negroes could not be citizens. The definition of state citizenship for white citizens, given in the number one quote from Mr. Taney above, still applies even to this day. The 14th Amendment never overturned that definition. It also never overturned the clear separation between who are people and who are persons, because these definitions were the legal skeletal structure of the Civil Rights Act of 1866, which became the 14th Amendment. So even to this day, there are people who are the white citizens of their respective state, for example, a Californian, and there are persons who are U.S. citizens or citizens of the United States. The 14th Amendment is the birth of a new class, new second class of citizen. Part 4. The interpretation of the 14th Amendment and clarity between state citizenship for the whites and U.S. citizenship for Negroes. After Dred Scott v. Sanford, our motion towards civil war accelerated. It wasn't the sole reason why we entered the Civil War, but it greatly accelerated the motion towards it. The 13th Amendment, which officially freed the enslaved Negroes, was ratified in December 1865. In retaliation to this, because the 13th Amendment was a congressional act, certain southern states passed what are called the Black Codes in 1865. These codes made it nearly impossible for the freed Negroes to even be there or work or live a decent life. Then Congress retaliated to this and passed the Civil Rights Act of 1866. The Civil Rights Act of 1866 was the solution Congress used to combat the Dred Scott decision as well as to combat the Black Codes of the South. The courts, the states, and Congress were at war over the subject of slavery, and the people of the country were swept into it. It was almost like a political war on the heels of the Civil War. As the smoke cleared to all of this, the normal citizens of America were attempting to make heads or tails of anything that had happened. There was confusion now over the old citizenship class compared to the new one that had been made. There was a series of many cases involving slaughterhouses that all got rolled into one massive Supreme Court case in order to address and clarify everything that had occurred. This case is, in my opinion, the most important and impactful case that we have ever had in the entire history of our legal system. This case is called the Slaughterhouse Cases, 83 U.S. 36 from 1873. In these series of cases, which had a singular finale, we have the breaking down and clarifying of how those two very different types of citizenship function in our country. Please carefully read the following quotes where I will again use bold words and underlines to bring your attention to specific parts of the communication from the Honorable Samuel Freeman Miller. The first section of the 14th article, to which our attention is more special. Oh, I think I might have confused earlier Samuel Freeman Miller with Roger B. Taney, but Samuel Freeman Miller was the guy that was like super duper into freeing the Negroes and freeing the slaves and giving them all of the good stuff in life. All right, so these are quotes from the Honorable Samuel Freeman Miller from the Slaughterhouse Cases. The first section of the 14th article, to which our attention is more specially invited, opens with a definition of citizenship, not only citizenship of the United States, but citizenship of the states. No such definition was previously found in the Constitution, nor had any attempt been made to define it by act of Congress. It had been the occasion of much discussion in the courts, by the executive departments, and in the public journals. It had been said that by eminent judges that no man was a citizen of the United States except as he was a citizen of one of the states composing the Union. Those, therefore, who had been born and resided always in the District of Columbia or in the territories through within the United States were not citizens. Then all the Negro race who had been recently made freemen, or who had been made freemen, were still not only not citizens, but were incapable of becoming so by anything short of an amendment to the Constitution. To remove this difficulty primarily, and to establish a clear and comprehensive definition of citizenship, which should declare what should constitute citizenship of the United States, and also citizenship of a state, the first clause of the first section was framed. The first observation we have to make on this clause is that it puts at rest both the questions which we stated to have been the subject of differences of opinion. It declares that persons may be citizens of the United States without regard to their citizenship of a particular state, and it overturns the Dred Scott decision by making all persons born within the United States and subject to his jurisdiction of the United States. That was the end of the sentence. That is, main purpose was to establish the citizenship of any of the Negro can admit no doubt. The phrase subject to its jurisdiction was intended to exclude from its operation children of ministers, consuls, and citizens or subjects of foreign states born within the United States. 4. The next observation is more important in view of the arguments of counsel in the present case. It is that the distinction between citizenship of the United States and citizenship of a state is clearly recognized and established. Not only may a man be a citizen of the United States without being a citizen of a state, but an important element is necessary to convert the former into the latter. He must reside within the state to make him a citizen of it, but it is only necessary that he should be born or naturalized in the United States to be a citizen of the Union. It is quite clear then that there is a citizenship of the United States and a citizenship of a state, which are distinct from each other, and which depend upon different characteristics or circumstances in the individual. We think this distinction and its explicit recognition in this amendment of great weight in this argument, because the next paragraph of this same section, which is the one mainly relied on by plaintiffs in error, speaks only of privileges and immunities of citizens of the United States and does not speak of those of citizens of the several states. Of the privileges and immunities of citizens of the United States and of the privileges and immunities of the citizen of the state, and what they respectively are, we will presently consider. But we wish to state here that it is only the former which are placed in this clause, or which are placed by this clause under the protection of the federal Constitution, and that the latter, whatever they may be, are not intended to have any additional protection by this paragraph of the amendment. If then there is a difference between the privileges and immunities belonging to a citizen of the United States as such, and those belonging to the citizen of the state as such, the latter must rest for their security and protection where they have heretofore rested, for they are not embraced by this paragraph in the amendment. You should take your time to read the above quotes over and over, as it's quite a lot to digest. So much, in fact, that almost no one since 1873 has really gotten a clear understanding of these two different classes. It should be noted that the vote in this case was split. Unlike the Dred Scott case, which had a massive majority vote, the Slaughterhouse cases was a 5-4 split, and the Chief Justice actually dissented on this vote. So even within the Supreme Court itself, it was tremendously hard to get an agreement on the outcome of this situation. Basically, in simple English, the U.S. citizen class was a class created under Congress in the District of Columbia in an attempt to protect the Negroes from being abused in the states. It is citizenship of the District of Columbia, and is not a class that exists under the Bill of Rights directly. It is a class that is protected by the District of Columbia, but those protections are under the discretion of Congress, not tied to the Bill of Rights directly. The individual sections of the Bill of Rights are cherry-picked by Congress in terms of which ones apply to the U.S. citizen class in a series of cases called the Incorporation Doctrine. These cases should change or shift at any time, but most of these decisions were made around the end of the 1800s and the middle of the 1900s, with some as late as 2010 and 2019. We'll talk more about the Incorporation Doctrine later in this treatise. Here is an excellent quote that helps paint the picture for you in more plain English. I know the Slaughterhouse case is a lot to take in. This case is Ellen R. Van Valkenburg v. Albert Brown, 43 California, 43, Supreme Court, 1872. Or California Supreme Court, 1872. Let's see what the Honorable California Chief Justice William T. Wallace has to say about the situation. No white person born within the limits of the United States and subject to their jurisdiction, or born without those limits and subsequently naturalized under their laws, owes the status of citizenship to the recent amendments to the federal Constitution. The history and aim of the 14th Amendment is well known, and the purpose had in view its adoption well understood. That purpose was to confer the status of citizenship upon numerous classes of persons domiciled within the limits of the United States who could not be brought within the operation of the naturalization laws because native born, and whose birth, though native, had at the same time left them without the status of citizenship. These persons were not white persons, but were in the main persons of African descent who had been held in slavery in this country, or if having themselves never been held in slavery, were native-born descendants of slaves. Prior to the adoption of the 14th Amendment, it was settled that neither slaves nor those who had become such, nor the descendants of these, though native and free-born, were capable of becoming citizens of the United States. Dred Scott v. Sanford, 18 Howe, 393. The 13th Amendment, though conferring the boon of freedom upon native-born persons of African blood, had yet left them under an insuperable bar as to citizenship, and it was mainly to remedy this condition that the 14th Amendment was adopted. So remember, guys, the 13th Amendment prohibited slavery, and the 14th Amendment granted citizenship to the persons that were previously slaves. It granted U.S. citizenship, otherwise, like District of Columbia citizenship. So it didn't give them state citizenship, it gave them United States citizenship. So basically, District of Columbia. Number 5, more information to fill in the gaps and give body to the above situation. So the very next day after the slaughterhouse cases, Mr. Miller was handling the confusion caused by all of this in a case called Bradwell v. State in 1873. Slaughterhouse was April 14th, 1873. Bradwell v. State was April 15th, 1873. These quotes are by Mr. Miller, the same judge who gave the final opinion in Slaughterhouse. I will bold one particular section I want to put your attention on. The record in this case is not very perfect, but it may be fairly taken that the plaintiff asserted her right to a license on the grounds, among others, that she was a citizen of the United States, and that having been a citizen of Vermont at one time, she was, in the state of Illinois, entitled to any right granted to citizens of the latter state. 2. As regards the provision of the Constitution that citizens of each state shall be entitled to all the privileges and immunities of citizens of the several states, the plaintiff in her affidavit has stated very clearly a case to which it is inapplicable. The protection designed by that clause, as it had been repeatedly held, has no application to a citizen of the state whose laws are complained of. If the plaintiff was a citizen of the state of Illinois, that provision of the Constitution gave her no protection against its courts or its legislation. So basically what he's saying is, because she was a state citizen, she could not claim the privileges and immunities that were granted by 14th Amendment citizenship. Because she was already a state citizen, she could not become a U.S. citizen, which is like the difference between the two. So there you go. 3, and this is another quote from Justice Miller. The plaintiff seems to have seen this difficulty and attempts to avoid it by stating that she was born in Vermont. While she remained in Vermont, that circumstance made her a citizen of that state. But she states at the same time that she is a citizen of the United States, and that she is now, and has been for many, many years, a resident of Chicago in the state of Illinois. We do not here mean to say that there may not be a temporary residence in one state with intent to return to another, which will not create citizenship in the former, but the plaintiff states that nothing to take her case out of the definition of citizenship of a state, as defined by the first section of the 14th Amendment. In regards to that amendment, counsel for the plaintiff in this court truly says that there are certain privileges and immunities which belong to a citizen of the United States. As such, otherwise, it would be nonsense for the 14th Amendment to prohibit a state from abridging them. And he proceeds to argue that an admission to the bar of a state of a person who possesses the requisite learning and character is one of those which a state may not deny. The bolded section above shows that Mr. Miller is saying that white citizens of a state have no right to the 14th Amendment at all. This is one of the most crucial quotes of anything ever said on the subject, so to keep it in the back of your mind as we talk more about this. The white citizens of the states never needed anything from the 14th Amendment. period. When you read Law of Nations by Vattel, this begins to take more shape because you learn that rights and obligations are tied together. Again, I'll say that again. Rights and obligations are tied together. So due to the fact that white citizens of a state do not have any rights under the 14th Amendment, they also do not have any obligations, such as driver's license, taxes, etc. These are all obligations tied only and directly to the 14th Amendment citizenship class, not to the state citizenship class. In order to fully understand the incredible weight of the above quotes, we should review the definitions of domicile versus resident. All right, and so this is from a whole bunch of stuff. I'm going to presume most of this is from Black's Law, but this is a whole bunch of case law right here, all of these little references. Domicile. 1. That place where a man has his true, fixed, and permanent home and principal establishment, and to which, whenever he is absent, he has the intention of returning. Not for a mere special or temporary purse, but with the present intent of making a permanent home for an unlimited or indefinite period. 2. Domicile and residence, however, are frequently distinguished in that domicile is the home and the fixed place of habitation, while residence is a transient place of dwelling. And this is from Fisher v. Jordan. So again, guys, remember this whenever like people ask you, are you a resident of this? Are you a resident of that? You know, this is the legal distinction between domicile and residence. Domicile is a permanent home and principal establishment to which you intend to return, and then residence is like a place where you're temporarily at. So just keep that in mind. All right, yeah, so we'll go on and further define residence. Residents, as distinguished from citizens, are aliens who are permitted to take up a permanent abode in the country. Being bound to the society by reason of their dwelling in it, they are subject to its laws so long as they remain there, and being protected by it, they must defend it, although they do not enjoy all the rights of citizens. They have only the certain privileges which the law or custom gives them. Permanent residents are those who have been given the right of perpetual residence. They are a sort of citizens of a less privileged character, and are subject to the society without enjoying all its advantages. Their children succeed to their status, for the right of perpetual residence given them by the state passes to their children. And this is from Vattel, Law of Nations, Chapter 19, on which like the United States Constitution was like formed, Law of Nations. 2. As domicile and residence are usually in the same place, they are frequently used as if they had the same meaning, but they are not identical terms. For a person must have two places of residence, as in the city and country, but only one domicile. Residence means living in a particular locality, but domicile means living in that locality with the intent to make it a fixed and permanent home. Residence simply requires bodily presence as an inhabitant in a given place, while domicile requires bodily presence in that place and also an intention to make it one's domicile. Residence demands less intimate local ties than domicile, but domicile allows absence for indefinite period if intent to return remains. So this is the important thing for domicile, intent to return. Holding that residence and domicile are synonymous terms, residence has a meaning dependent on context and purpose of statute. Words residence and domicile may have an identical or variable meaning depending on the subject matter and context of statute. So we can see by the above that people are already confused about this whole U.S. citizen thing. In this case, we have the original state of domicile, another state of residence, and this lady also saying she is a U.S. citizen and has rights under the 14th Amendment. Quite confusing. But you can see the Honorable Mr. Miller shut that shit down and let her know that she has no rights to the 14th Amendment as a state citizen. It is quite clear and quite simple. In 1876, we have one of the most well-known cases in our entire history, United States v. Cruikshank. 1876. This one had a pretty even split down the middle of a 5-4 vote, with our boy Mr. Miller in agreement with the decision. This case involved a massacre where an armed white militia killed many black freemen at a courthouse. The black freedmen were protesting the 1872 election of the governor of Louisiana by occupying the courthouse. When reading this, keep in mind that legal fictions were not added in as persons under the 14th Amendment until 1886, which we will obviously cover in detail later in this treatise. This opinion was written by Chief Justice of the time, Mr. Morrison Remick Mott Waite. Let's get into some quotes, and I'll underline in bold one important part that I would like you to see. Quote number 1. We have in our legal system a government of the United States and a government of each of the several states. Each one of these government is distinct from the others, and each has citizens of its own who owe it allegiance and whose rights within its jurisdiction it must protect. The same person may be at the same time a citizen of the United States and a citizen of a state, but his rights of citizenship under those governments will be different from those he has under the other. And this is from Slaughterhouse Cases. The 14th Amendment prohibits a state from depriving any person of life, liberty, or property without due process of law, but this adds nothing to the rights of one citizen against another, or this nothing to the rights of one citizen as against another. It simply furnishes an additional guarantee against any encroachment by the states upon the fundamental rights which belong to every citizen as a member of society. In 1901, we have the case Downs v. Bidwell, which indirectly describes the two distinct classes of citizenship classes perfectly. The Honorable Justice Henry Billings Brown says the following: "We have in this country, substantially or practically, two national governments, one to be maintained under the Constitution with all its restrictions, and the other to be maintained by Congress, outside and independently of that instrument, by exercising such powers as other nations of the earth are accustomed to exercise." So again, guys, important quote. We have in this country substantially or practically two national governments. One to be maintained under the Constitution with all its restrictions. The other to be maintained by Congress outside and independently of that instrument by exercising such powers as other nations of the earth are accustomed to exercise. So basically, there's two governments in the US: the constitutional government for state citizens and the congressional government for US citizens, right? So you have state citizens and you have United States citizens. So again, two governments, one ran by the Constitution under common law, and the other ran by Congress under administrative law. We'll get into that later. In the case Hague v. Committee for Industrial Organization, we have the following quotes by the Honorable Justice Owen J. Roberts. After the adoption of the 13th Amendment, a bill which became the first Civil Rights Act was introduced in the 39th Congress, the major purpose of which was to secure to the recently freed Negroes all the civil rights secured to white men. This act declared that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, were citizens of the United States and should have the same rights in every state to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, lease, sell, hold, and convey a real and personal property, and to enjoy the full and equal benefit of all laws and proceedings for the security of persons and property to the same extent as white citizens. None other than citizens of the United States were within the provisions of the Act. 2. By reason of doubts as to the power to enact the legislation, and because the policy thereby evidenced might be reversed by a subsequent Congress, there was introduced at that same session an additional amendment to the Constitution, which became the 14th. So again, guys, 13th Amendment freed all the slaves. 14th Amendment freed all the Negroes, the persons, as is like described in the Constitution, and then the 14th Amendment secured for them a whole bunch of like rights and things. So there you go. But the 14th Amendment only secured those rights for the like US citizenship class. It was the class that was created by the 14th Amendment that was separate from the state citizenship class. In the case Madden v. Commissioner 309 US 83 in 1940, the Honorable Stanley Foreman Reed says the following: "This position is that the Privileges and Immunities Clause protects all citizens against abridgment by states of rights of national citizenship, as distinct from the fundamental or natural rights inherent in state citizenship. The court declared in the Slaughterhouse Cases that the 14th Amendment, as well as the 13th and 15th, were adopted to protect the Negroes in their freedom. This almost contemporaneous interpretation extended the benefits of the Privileges and Immunities Clause to other rights which are inherent in national citizenship, but denied it to those which spring from state citizenship. In applying this constitutional principle, this court has determined that the right to operate an independent slaughterhouse, to sell wine on terms of equality with grape growers, and to operate businesses free of state regulation were not privileges and immunities protected by the 14th Amendment. An estate inheritance tax statute, which limited exemptions to charitable corporations within the state, was held not to infringe any right protected by the Privileges and Immunities Clause. The court has consistently refused to list completely the rights which are covered by the clause, though it has pointed out the type of rights protected. We think it quite clear that the right to carry out an incident to a trade, business, or calling such as the deposit of money in banks is not a privilege of national citizenship. So they can take money out of your bank, boys. There you go. In the case Jones v. Temer, Colorado 1993, or District of Columbia 1993, the Honorable Louis T. Babcock says the following. Important note, this is only persuasive authority as it is not an appeals or Supreme Court decision. So it's just persuasive authority. The Privileges and Immunities Clause of the 14th Amendment protects very few rights because it neither incorporates any of the Bill of Rights nor protects all rights of individual citizens. See Slaughterhouse Cases. Instead, this provision only protects only those rights peculiar to being a citizen of the federal government. It does not protect those rights which relate to state citizenship. Accordingly, it is not necessary that plaintiffs have non-resident status in order to bring a claim under the Privileges and Immunities Clause of the 14th Amendment. Here's the first part of the veto message on 3/27/1866 by President Andrew Johnson regarding the Civil Rights Act of 1866. Is Andrew Johnson a president? Hang on a second. That might mean Andrew Jackson. I'm not positive. President Andrew Johnson. Oh, I stand corrected. Well, I'll be damned. There we go. President Andrew Johnson. Okay. Regarding the Civil Rights Act of 1866, I recommend that you read this entire message. I regret that the bill, which has passed both houses of Congress, entitled An Act to Protect All Persons in the United States in their Civil Rights and Furnish their Means of their Vindication, contains provisions which I cannot approve consistently with my sense of duty to the whole people and my obligations to the Constitution of the United States. I am therefore constrained to return it to the Senate, the House, in which it originated, with my objections to its becoming a law. By the first section of the bill, all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are declared to be citizens of the United States. This provision comprehends the Chinese of the Pacific states, Indians subject to taxation, the people called gypsies, as well as their entire race designated as blacks, people of color, Negroes, mulattoes, and persons of African blood. Every individual of these races born in the United States is, by the bill, made a citizen of the United States. It does not purport to declare or confer any other right of citizenship than federal citizenship. It does not purport to give these classes of persons any status as citizens of states, except that which may result from their status as citizens of the United States. The power to confer the right of state citizenship is just as exclusively with the several states as the power to confer the right of federal citizenship is with Congress. So, important part there, guys. The states can make state citizens, and the federal government can make federal citizens. So, some things to chew on. This is again what President Andrew Johnson said. This quote was said in U.S. v. Otherson in 1980 by the Honorable Harry Pedersen. The court was investigating the intent behind the Enforcement Act of 1870. The Senate further explained the Civil Rights Bill had several other things applying to citizens of the United States. This simply extends to foreigners, not citizens. The protections of our laws, where the state laws deny them the equal civil rights enumerated in the first section. Finally, we note that appellant's interpretation would hamper achievement of the statute's purpose. Senator Stewart's remarks revealed that the 1870 Act was intended to safeguard the legal rights of aliens present in this country. In Heard v. Hodge, 1948, the Honorable Justice Fred M. Vinson says, both the Civil Rights Act of 1866 and the joint resolution, which was later adopted as the 14th Amendment, were passed in the first section of 39th Congress. Frequent references to the Civil Rights Act are to be found in the record of the legislative debates on the adoption of the amendment. It is clear that, in many significant respects, the statute and the amendment were the expressions of the same general congressional policy. Indeed, as the legislative debates reveal, one of the primary purposes of many members of Congress in supporting the adoption of the 14th Amendment was to incorporate the guarantees of the Civil Rights Act of 1866 in the organic law of the land. In the case of Paul v. Virginia, 1869, the Honorable Stephen Johnson Field said the following, proving that a corporation is not able to be a citizen of a state. It was contended that the statute in this particular was in conflict with that clause of the Constitution which declares that citizens of each state shall be entitled to all the privileges and immunities of citizens of the several states, and the clause which declares that Congress shall have power to regulate commerce with foreign nations and among the several states. The same grounds are urged in this court for the reversal of the judgment. The answer which readily occurs to the objection found upon the first clause consists in the fact that corporations are not citizens within its meaning. The term citizens as they're used applies only to natural persons, members of the body politic, owing allegiance to the state, not to artificial persons created by the legislature and possessing only attributes which the legislature has prescribed. So artificial persons are a real thing as well. So like an artificial person would be something like a corporation. That's the easy example. So artificial persons are corporations, corporations are artificial persons. So basically, what it's saying is that corporations cannot become state citizens. The state citizen category is still alive and well when reviewing federal jurisdiction statutes. Let's take a look at 28 USC subsection 1332, which is typically referred to as diversity jurisdiction. A. The district court shall have original jurisdiction of all civil actions where the matter in controversy exceeds the sum or value of $75,000, exclusive of interest and costs, and is between citizens of different states. The above quote has been terribly misunderstood for such a long time because corporations and other legal fictions would actually not fit the above definition at all, as covered by the Hepburn and Dundas v. Elsie of 1805. I'm going to post the entire final opinion by Justice John Marshall on this case, as this final opinion essentially clarifies with great power the two entirely separate governments that we have in America. So, the question in this case is whether the plaintiffs, as residents of the District of Columbia, can maintain an action in the Circuit Court of the United States for the District of Virginia. This depends on the act of Congress describing the jurisdiction of that court. That act gives jurisdiction to the circuit courts in cases between a citizen of the state in which the suit is brought and a citizen of another state. To support the jurisdiction in this case, therefore, it must appear that Columbia is a state. On the part of the plaintiffs, it has been urged that Columbia is a distinct political society and is therefore a state according to the definition of writers on general law. This is true, but as the act of Congress obviously uses the word state in reference to the term as used in the Constitution, it becomes necessary to inquire whether Columbia is a state in the sense of that instrument. The result of that examination is a conviction that the members of the American Confederacy are only are the states contemplated in the Constitution. The House of Representatives is to be composed of members chosen by the people of the several states, and each state shall have at least one representative. The Senate of the United States shall be composed of 2 senators from each state. Each state shall appoint for the election of the executive a number of electors equal to its whole number of senators and representatives. These clauses show that the word state is used in the Constitution as designating a member of the Union and excludes from the term the significant attached to it by writers on the law of nations. When the same term, which has been used plainly in this limited sense in the articles respecting the legislative and executive departments, is also employed in that which respects the judicial department, it must be understood as retaining the sense originally given to it. Other passages from the Constitution have been cited by the plaintiffs to show that the term state is sometimes used in its more enlarged sense, but upon examining the passages quoted, they do not prove what was to be shown by them. It is true that as citizens of the United States and of that particular district which is subject to the jurisdiction of Congress, it is extraordinary that the courts of the United States, which are open to aliens and to the citizens of every state of the Union, should be closed upon them. But this is a subject for legislative, not judicial consideration. As you can see, the word state shifts. If you are speaking about the Republic of Sovereign States, the word state refers to places like California or Utah. Whereas in federal codes, the word state means only District of Columbia and areas that are under its direct control. In this case, it is still just as active and functional as it was in 1805, and all U.S. citizens or citizens of the United States may not sue a white citizen of a state in federal court. The problem is simply that no one has brought up this claim in any case in hundreds of years. At this point, let's go even further and show direct and exact quotes from the Constitution that show, with clarity, that citizenship was attached to one of the states of the Union, not of national origin. Article 3, Section 2, Clause 1. Between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens or subjects. As well as Article 4, Section 2, Clause 1. Citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. In the infamous Susan B. Anthony case, which is U.S. v. Anthony, 1873, right on the heels of the Slaughterhouse case, which was decided in April 14th, 1873, we have some very important quotes that should be covered. It should be noted that while this case is only persuasive authority because it was not in an appeals court or in the Supreme Court, the final opinion was given by a sitting U.S. Supreme Court Associate Justice who is one of the 5 justices that approved the Slaughterhouse case's decision. So these quotes should be taken as extremely important, as Mr. Hunt was literally right in the room as talks were occurring regarding the Slaughterhouse cases, and he was in agreement with the final opinion in the case. A video of me breaking down this incredibly important clause is here. Let's take a look at this video real quick. All right, research time with Brandon critiquing the Susan B. Anthony criminal federal circuit case. So that's where you guys can see it. There's a beautiful freeze screen of Brandon Joe Williams. You look great, broski. We're gonna give you a like. So this was 5 months ago, and this is a critique of the Susan B. Anthony case. So there you guys go. If you want to watch it, that's it. Bam. All right, here are some of the quotes from the Honorable Supreme Court Justice Ward Hunt in this case. I will use bolds and underlines to bring your attention to specific important points. The 14th Amendment creates and defines citizenship of the United States. It had long been contended and had been held by many earned authorities and had never been judicially decided to the contrary, that there was no such thing as a citizen of the United States, except as that condition rose from citizenship of some state. No mode existed, it was said, of obtaining citizenship of the United States, except by first becoming a citizen of some state. After creating and defining citizenship of the United States, the 14th Amendment provides that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. This clause is intended to be a protection, not to all our rights, but to our rights as citizens of the United States only. That is, to rights existing or belonging to that condition or capacity. The expression, citizen of a state, used in the previous paragraph is carefully omitted here. In Articles 4, subsection 2, first point of the Constitution of the United States, it had already been provided that citizens of each state shall be entitled to all privileges and immunities of the citizens in the several states. The rights of the citizens of the states and of citizens of the United States are each guarded by these different provisions. That these rights are separate and distinct was held in the Slaughterhouse cases. The rights of citizens of the state, as such, are not under consideration in the 14th Amendment. They stand, as they did, before the adoption of the 14th Amendment and are fully guaranteed by other provisions. The case of Bradwell v. State, 16 Wall, decided at the recent term of the Supreme Court, sustains both the positions above put forth. First, that the rights referred to in the 14th Amendment are those belonging to a person as a citizen of the United States and not as a citizen of a state. And second, that a right of the character here involved is not one connected with citizenship of the United States. Miss Bradwell made application to be admitted to practice as an attorney and counselor at law in the courts of Illinois. Her application was denied, and upon a writ of error, it was held by the Supreme Court that, to give jurisdiction under the 14th Amendment, the claim must be of a right pertaining to citizenship of the United States, and that the claim made by her did not come within that class of cases. The final thing that we should cover in this section is that the term United States citizen was in usage before its official legal birth in the 14th Amendment. So what did it mean prior to 1868? That was beautifully answered by Justice Solomon Haydenfeld in the case Ex parte Knowles in 1855. 1. In examining the form of our government, it might be correctly said that there is no such thing as a citizen of the United States. But constant usage, arising from convenience or perhaps necessity, and dating from the formation of the Confederacy, has given substantial existence to the idea which the term conveys. A citizen of any one of the states of the Union is held to be and called a citizen of the United States, although technically and abstractly there is no such thing. To conceive a citizen of the United States who is not a citizen of one of the states is totally foreign to the idea and inconsistent with the proper construction and common understanding of the expression as used in the Constitution, which must be deduced from its various other provisions. The object then to be attained by the exercise of the power of naturalization was to make citizens of the respective states. 2. The states had the power to naturalize foreigners, and there was no necessity for this power to be surrendered to the general government. Hence, the necessity arose not that Congress should have the power to naturalize it, but should have the power to prescribe to the states a rule to be carried out by them, and which should be uniform in each. If this were not so, it follows conclusively that there was no mode by which a foreigner can be made expressly a citizen of a state. For I have already shown that there is no such thing, technically, as a citizen of the United States, Consequently, one who is created a citizen of the United States is certainly not made a citizen of any particular state. It follows that as it is only the citizens of the state who are entitled to all privileges and immunities of citizens of the several states, if the process is left alone to the action of Congress through her federal tribunals, and in the form which they have adopted, then a distinction both in name and privileges is made to exist between citizens of the United States, ex via termini, by definition, and citizens of the respective states. To the former, no privileges or immunities are granted, and it will hardly be contended that political status can be derived by implication against express legal enactments. Part 6. The expanding of the word persons to include artificial fictions. All right, guys, I'm going to take a break, and I got to go get a glass of water because, my goodness, am I of parched thirst right now. So I hope you guys are enjoying this process. I hope that it all makes sense. If you guys have any questions or concerns or comments or anything, like, I would love to hear them because let me tell you, this stuff is some heavy thing, and like, it's difficult to understand. It's difficult to comprehend. It's difficult to read. So like, the more that we have some groupthink on this, and the more that we can, go through this process of reasoning and thinking together, then probably the better off that we will be in our journey of understanding and learning of things. So currently pouring myself a delicious glass of cranberry juice and watered down vinegar, and we're gonna have that as our hydration station. So give me one moment, guys, and I will return to the camera, and then we will get back to reading this document once I have rehydrated my human corporeal body. So let's see, checking for any comments. If there are any comments, if there are any thoughts, I'd be happy to hear them. So okay, good enough for now, I suppose. All right. Expanding of the word persons to include artificial fictions. Section 6. In 1873, due to the slaughterhouse cases, the delineating point between who was persons and who were people was simply the distinction between white man and a Negro. That's simple, let's not sugarcoat it. But in 1871, during the Reconstruction of America after the Civil War, we have something called the Dictionary Act of 1871, which you can still see at the very beginning of the United States Code at 1 USC subsection 1. The term person was defined as, and is still defined as, the words person and whosoever include corporations, companies, associations, firms, partnerships, societies, and joint stock companies, as well as individuals. So there you go. 1 USC subsection 1. But this original definition from the Dictionary Act of 1871 only applied originally to federal statutes, meaning it did not apply to state applications directly. It wasn't until one specific case when this definition of person from the Dictionary Act began to expand and become more commonly acceptable, which I will speak about now. This case was Santa Clara County v. Southern Pacific Railroad Company, uh, and there's the number thing. So it's from 1886. This case clearly expanded the 14th Amendment's definition of persons, meaning Negroes. Here is the exact quote from that case that caused that to occur. One of the points made and discussed at length in the brief of counsel for defendants in error was that corporations are persons within the meaning of the 14th Amendment to the Constitution of the United States. Before argument, Chief Justice Waite said, "The court does not wish to hear the argument on the question whether the provision in the 14th Amendment to the Constitution, which forbids a state to deny any person within its jurisdiction the equal protection of the laws, applies to these corporations. We are all of the opinion that it does." This is where the Supreme Court began the expansion of the 14th Amendment. Definition of person, which has nothing to do with free white people, of state citizenship. This definition expansion of meaning only applies to the 14th Amendment, not to state citizenship or men of the Union, meaning white people who are actual state citizens. The 14th Amendment never had anything to do with white people and state citizens. The original 10 amendments were for us. This is the Bill of Rights. That was for us, the white people, while the 14th Amendment was specifically made for the Negroes. The 14th Amendment is the Bill of Rights for the Negroes. So like that's an easy way to remember it. Now, like skipping over the bombastic language, that's essentially what it means. I want to take a moment and diffuse emotional outburst. We are looking at active laws that may be considered ancient from our perspective. We need to understand the situation and laws first prior to our ability to change or unshape them. This is why I'm attempting, or that is all I'm attempting by this. I'm a lowly researcher. The decisions of the American people or persons must come first from a place of understanding, then ultimately from independent thought and action. I am not a lord in these discussions. I am simply the messenger attempting to translate the words of the various honorable justices and the legal terminology. I am simply attempting to be a legalese translator, which has never really existed prior to this blip in time, but I attempt to be no lord over these words. I want to successfully translate these things in order to create and change our culture. When you actually take the time to read the words of these honorable justices, you quickly realize that they were not racist pieces of shit. They were simply trying to understand the situation and navigate a difficult situation the best they could. If anything, they were putting their life on the line by even speaking a word trying to protect the Negroes or give them any kind of freedom. The Civil War had just ended, and one wrong word in these cases had the possibility of catapulting us back into the war. The issue here is not the words of these honorable justices. I say honorable because they were. The problem is that their words were lost in translation and no one reads their original communications anymore. Stop using artificial intelligence, stop listening to the media, stop listening to your friends, and take the time to carefully read and understand what these honorable justices were trying to tell you. They are telling you everything you need to archive on your freedom, I assure you. Mr. Miller, Mr. Taney, Mr. Wallace, and a vast majority of all the honorable justices in our past were brilliant men. If you take the time to understand their words, you will see that. So, how does the federal aspect of citizenship work after legal fictions were added in as persons? Let's review some of the current definitions of the words. In Title 8 of the U.S. Code, person is defined in 8 U.S.C. subsection 1101 Bravo 3 as the term person means any individual or an organization. The term individual is not specifically defined and thus defaults to the dictionary definition. Here is one from Black's Law, 4th edition. Yeah, I like how they say person means an individual or organization, and they never talk about what is an individual. So for Black's Law, as a noun, this term denotes a single person as distinguished from a group or class, and also, very commonly, a private or natural person as distinguished from a partnership, corporation, or association. But it is said that this restrictive signification is not necessarily inherent in the word, and that it may, in proper cases, include artificial persons. So as you can see, the definition above allows it to also include artificial persons. Then finally, we have the term organization from Title 8 definition of person, which is defined in 8 U.S.C. subsection 1101A28. The term organization means, but is not limited to, an organization, corporation, company, partnership, association, trust, foundation, or fund, and includes a group of persons, whether or not incorporated, permanently or temporarily associated together with joint action on any subject or subjects. So there you go. They define organization, they don't define individual. Black's Law defines individual, but they do define organization in 8 USC 1101 A28. So as you can see, the above, you can actually open up businesses or trusts and go get passports for them because they are technically persons, that they are U.S. citizens. Technically, persons are U.S. citizens. In order to fully understand this, we need to clear up the definition of birth from a legal dictionary. The act of being born or wholly brought into separate existence. With that definition in mind, let's take a look at the actual legal section that everyone in America believe applies to them, which is 8 USC subsection 1401. The following shall be nationals and citizens of the United States at birth. A person born in the United States and subject to the jurisdiction thereof. Without getting too far into it, keep in mind that the definition of United States in all federal codes is basically the District of Columbia, any U.S. territory and insular possession, and also any area within the special maritime or special territorial jurisdiction of the District of Columbia. So remember, guys, the United States is defined in basically all federal codes as the District of Columbia. So citizens of the United States are people that are born in the District of Columbia. Bazinga. Or any of the territories, insular possessions, and maritime, blah, 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 blah. Or more simply, any area under the direct control of the District of Columbia. This does not include states such as California or Texas. So let's rewrite the above section from 8 USC 1401 in English to better understand it. The following shall be nationals and citizens of the United States at birth. An individual or organization being wholly brought into separate existence in any area under the direct control of the District of Columbia and subject to the jurisdiction thereof. Now that the part about the above that is so shocking is that all organizations that come into their existence would technically be U.S. citizens. You can see this in 15 USC subsection 4724E1. The term United States business means A United States citizen, B, a corporation, partnership, or other association created. Isn't that fucking cool? The United States business means a U.S. citizen. Wow. Imagine that, guys. A business is a citizen. A corporation, partnership, or other association created under the laws of the United States or of any state, including the District of Columbia or any Commonwealth territory or possession of the United States, or a foreign corporation, partnership, or other association, more than 95% of which is owned by persons described in subparagraphs A and B. So what this means in English is basically any organization at all created in the United States is a person and is a U.S. citizen. Any foreign person owned by any one of these persons is also under our jurisdiction. The most fascinating and shocking application of this is actually on the states. For example, state of California is listed on Dun & Bradstreet as a business and has an EIN number. State of California is an organization, which means it is a person and experienced birth in an area under direct control of the District of Columbia. So that means that state of California is technically a U.S. citizen. This is exactly how our original republic was destroyed. It was flipped from the states having all the power to the District of Columbia having all the power. So let's take an example of all this and let's put it into action. Let's go to the California Vehicle Code and attempt to find out who or what actually the code applies to. This is the code all about cars, speed limits, tickets, etc. Let's start with the definition of a resident from section 516 of the code. Resident means any person who manifests an intent to live or to be located in this state on more than a temporary or transient basis. Presence in the state for 6 months or more in any 12-month period gives rise to a rebuttable presumption of residency. Now, obviously, we see the word person in there, so we need the definition to have this make sense. We can get this definition from section 470. Person includes a natural person, firm, corporation, association, limited liability, or corporation. So the obvious definition of the word person means, in English, any man, woman, child, or legal fiction with rights and obligations under the 14th Amendment. Boom. There you go. The way you know this is because legal fictions such as corporations were entered in as persons under the 14th Amendment, but were never allowed to be a part of we the people as state citizens. You can also tell because legal fictions have no right on the 9th or 10th Amendments, which would override the entire vehicle code, making it inapplicable. So, in order to understand the California Vehicle Code applies to, we need to combine these definitions, which I will do here. Resident means any man, woman, child, or legal fiction with rights and obligations under the 14th Amendment who manifests an intent to live or be located in the state on more than a temporary or transient basis. Presence in the state for 6 months or more in any 12-month period gives rise to a rebuttable presumption of residency. Okay, now it's starting to make more sense. Now there is a list of items in section 516 which describe evidence that a person can use, if they so please, to willingly or voluntarily register their vehicle with the state. Let's look at that list here. The following are evidence of registry for purposes of vehicle registration: address where registered to vote, location of employment or place of business, pay or resident tuition at public institution of higher education, attendance of dependents at primary or secondary school, filing a homeowner's property tax exemption, renting or leasing a home for use as residence, declaration of residency to obtain a license or any other privilege or benefit not ordinarily extended to a non-resident, possession of a California driver's license, other acts, occurrences, or evidence or events that indicate presence in the state is more than temporary or transient. So what they're saying is that the above points are valid evidence that you are a resident in order to get a vehicle registration. So it goes without saying, if you didn't have any of the above points, then you would not be able to register your car, which is exactly correct. In this situation, you would be a non-resident and you would operate in California under the California Vehicle Code section 6700, which allows non-residents to operate in the state without registration because they are physically incapable of getting registration if they are not a resident. So the idea that you must have a driver's license or vehicle registration to operate on the roadways is only true if you are a resident, but is not true and factually impossible for non-residents. Boom, baby. In essence, if you believe that being a resident means you live there, when in actuality it means someone living here who is not a citizen of the state. So by getting vehicle registration, you are essentially admitting that you are not a real American, but you are a visitor of some kind. Your allegiance and citizenship lies elsewhere. By reverse engineering this list, you can give yourself an excellent and simple program on how to break this presumption of residency, because a resident is a foreigner and not a citizen of the state. So, to put all this in English, you are probably a state citizen with your own business, which is a U.S. citizen called a sole proprietorship. This business is a resident in a state, but how does a legal fiction which has no physical body or location get located in a state? Well, that answer is found in 8 USC 1101A23. The term naturalization means the conferring of nationality of a state upon a person after birth by any means whatsoever. Let's replace the word person with the definition for more clarity. The term naturalization means the conferring of nationality of a state upon an individual organization after birth by any means whatsoever. Bingo, that makes perfect sense. So basically, a corporation is a resident in a state because people say so. Not even kidding. I know that sounds ridiculous, but that's literally how it works. If you or anyone else says that your corporation or any other corporation is a resident in a state, then voila, it is. It's magic. Once you understand this, then you understand that you are able to move any legal fiction wherever you want and whenever you want. And this is a very powerful piece of information. And this is essentially how the citizenship system works in America. So let's say I was a French citizen and I wanted to move to America. No problem. I would just create, and so, like, look, if any of you guys are foreigners and you want to be a 14th Amendment citizen in the United States, you just do this right here. So let's say I was a French citizen and I wanted to move to America. No problem. I would just create a corporation called Brandon Joe Williams. I would get an EIN number from it from the IRS, and then I would say, meaning naturalize, this brand new citizen into California. And voila, now I am a resident of California without having to do any of the tests or even the 5-year residency period. Magic. You wouldn't be able to do this with state citizenship though. It's a trick that only works for US citizenship. The reason why is because legal fictions cannot be state citizens. So every time you say that you live someplace like California, in law, they are presuming that you are referring to your sole proprietorship, which is your business. So like your Social Security identity, it's a separate entity from you, right? So there is you, the physical flesh and body person, and then there is your sole proprietorship, which is essentially your bank account that allows you to do unlimited borrowing and lending and get jobs and transfer this digital bullshit that we call money, right? All that happens underneath the sole proprietorship, underneath your social security card. So you can move your social security card anywhere you want by doing exactly this process here. This is why your name is typically spelled in all caps, and this is why you are considered a resident on everything. Only none of it is referring to you, the squishy meat sack. It's referring to your business. If you look on your W-9 tax form, you are considered the owner of the sole proprietorship. So there you go. Actually, as a matter of fact, I wonder if I have a blank W-9 here. I was filling out W-9s earlier for employment stuff, and so I know I have one. Ooh, there's the I-9. Oh, there's a W-8BEN. Okay, I do not have a W-9. I have an I-9. Maybe he's referring to the I-9. That would make sense. Employees must complete section I-9. Oh wow, I have not filled out a W-9. Okay. Well, there we go. So, anyways, when you look on a W-9 tax form, you know what? Actually, we're gonna do that right now. Okay. Referring to your business, the sole proprietorship. Okay. Ooh, there we go. Perfect. Hey, look at that, guys. Right fucking there. Name of entity / individual. An entry is required. For a sole proprietor or disregarded entity, enter the owner's name on line 1 and enter the business or disregarded entity's name on line 2. So, like, bam, there it is. So if you put your name down in here, right, they're going to presume that you are the owner. So, bazinga. Oh, excuse me. Business name if different from the above. Yeah, so if it's different, then it'll go down here. Oh, excuse me. All right. And by the way, you guys can learn how to fill out these forms by checking out Brandon Joe Williams' his contract killer course number 2. He's got it's all public now, so you guys can check out how to fill out a W-9, a W-8, BEN, all that stuff. You are considered the owner of the sole proprietorship. All right, section 8, the Magna Carta. Oh boy, an individual sovereignty compared to collective sovereignty. Hey, we just read the Magna Carta, I think. Didn't we? I think we read the Magna Carta. I'm pretty sure that's the thing that we read. I want to say that's what that other book club was all about. I'm fairly positive. Aha, yep, the Magna Carta book club, the last book club that we did about 2 weeks ago. So, bazinga, we did read the Magna Carta. We need to stop for a minute and go on a bit of a very important detour in order to fully understand the main difference between state and federal U.S. citizenship. We have 2 big hints about this in both Dred Scott v. Sanford and Slaughterhouse, one by Mr. Taney and one by Mr. Miller. In Dred Scott v. Sanford, Mr. Taney says, the words people of the United States and citizens are synonymous terms and mean the same thing. They both describe the political body who, according to our Republican institutions, form the sovereignty and who hold the power and conduct the government through their representatives. They are what we familiarly call the sovereign people, and every citizen is one of this people and a constituent member of this sovereignty. In Slaughterhouse, Mr. Miller says, the people of this country brought with them to its shores the rights of the Englishmen, the rights which had been wrested from the English sovereigns at various periods of the nation's history. One of these fundamental rights was expressed in the words found in the Magna Carta: no free man shall be taken or imprisoned to be disseized of his freehold or liberties or free customs, or to be outlawed or exiled, or otherwise destroyed. Nor will we pass upon him or condemn him but by lawful judgment of his peers or by the law of the land. I have never looked into the Magna Carta because it is something that is mentioned on so many sovereign citizen hit piece articles that I wasn't sure it was relevant. But seeing so many justices speak about it at the Supreme Court in the 1800s, I began to look at it more closely because I realized that it might be quite important for it to be talked about so much. To see this for yourself, simply go to Google Scholar, click the law case bubble, and check only the appeals and Supreme Court decisions for your zone. Then type Magna Carta or Magna Charta. Some justices spell it as Magna Carta, and sometimes they spell it as Magna Charta. So please be mindful when searching for cases regarding it. Click this link to be taken right to the Supreme Court search results for Magna Carta. Look at this. Bam. Oh my goodness, look at all these listings. Wowee. That's pretty good. 508 results. So there you go. Bam. Magna Carta is what extended the powers of the king into the people and is the same basic structure of each of the individual states of the Union in America. You should think of these 50 states as independent little Englands that operate under the Magna Carta in essence, and it would be a great starting place to understand the differences between the states and the territories. Territories meaning like District of Columbia, Guam, Puerto Rico, American Samoa, the US Virgin Islands, and the Northern Mariana Islands. These territories operate under an entirely different system. So, what I want to speak about here is what Mr. Taney was talking about when he was talking about how the citizens form the sovereignty and how that relates to individual sovereignty. This is a huge misunderstanding in this world of teaching information as regards to sovereignty. This sovereignty is collective primarily, and then individual secondarily. What I mean by that is that it's a sovereignty that is held by the group. And what I mean by the group is the state. So, for example, a political body, to quote Mr. Taney, of sovereignty would be California. And then the constituent members, to quote Mr. Taney, of that sovereignty would be white Californians or state citizens. U.S. citizens are not part of this and do not compromise any of the 50 political bodies of sovereignty in the United States of America. This is exactly how the grand jury indictment system works. You have 23 or so members of this collective sovereignty, all pressing judgment on another member of that political body. But you need to be a member of this political body in order to access that collective sovereignty. This is where the most sovereignty gurus, including myself, have really been off the rails. Individual sovereignty is possible as someone who is neither a state citizen or U.S. citizen. They would be considered stateless, but they do not have the protections of the Bill of Rights and the Constitution, like you may believe, because they are not parties to it. Just like how Negroes were not originally parties to it, people who are not state citizens are also not party to it. This is exactly where the term resident alien came from. This term means persons who are not members of the sovereignty and are here in our zone as immigrants or guests. You could almost go as far as to say the term people is defined as white men and women who are parties to the Constitution by being citizens of their respective state of the Union. Then you could define persons as non-white men, women in legal fictions that are not at all or only partially parties to the Constitution, due to them either only being guests or not qualifying for state citizenship. This would be an excellent delineation. The problem we face is that very few people are members of the political bodies that compromise the sovereignty. Anyone identifying as a U.S. citizen would not be a member of this sovereignty. So the term sovereign citizen sort of gains an entirely new look through this lens. A sovereign citizen is simply a member of this sovereign body, and they help to compose the body of sovereignty that operates under the same basic fundamentality or functionality as the Magna Carta. Then, being a functional and contributing member of that sovereignty, collectively, you have access to tremendous personal and individual sovereignty. This is an important distinction and has been one of the primary areas that we as researchers and litigants have fallen down badly. The "you can't catch me because I'm not a citizen, I'm not in your jurisdiction" mentality is the main point of failure in all our groups. We need to properly regroup the 50 political bodies that form collective sovereignties, so each of the 50 independent nation states, and we need to assist one another to reform these political bodies and then operate these political bodies in relationship with the District of Columbia. We need to clean up DC as well because it's essentially a runaway train that's been hijacked by the insane. I recommend you research more on the subject and search around and find more quotes regarding honorable justices speaking about Magna Carta, because that appears to be the spinal cord of the functionality of state citizenship. Section 9. An expansive view into the term Negro. People use the term African American and other terms in an attempt to be kind, but what no one realizes is that the term African American basically enslaves anyone who accepts it. Mostly white people do it, let's be honest. Let's take some time to carefully break down the exact and specific term of Negro as used by the Honorable Justice Miller and others. Here is the legal definition of the term Negro from Black's Law, 4th edition. The word Negro means a black man, one descended from the African race, and does not commonly include a mulatto. But the laws of the different states are not uniform in this respect, some including the description of Negro, one who has 1/8 or more of African blood. The term Negro means necessarily person of color, but not every person of color is Negro. Now, let's right away get into the legal definition of mulatto to ensure clarification. A person that is the offspring of a negress by a white man or a white woman by a Negro. This is from Thurman v. State. In a more general sense, a person of mixed Caucasian and Negro blood or Indian and Negro blood. Properly, a mulatto is a person one of whom parents is wholly black and the other wholly white. But the word does not always, though perhaps it does generally, require so exactly even a mixture of blood, nor is its signification alike in all the states. Some other terms we should clear up are African descent, black, color, and colored. African descent. Persons of African nativity or of African descent, meaning within the nation or within the meaning of the Naturalization Act as amended, are members of the Negro races of Africa or their descendants by intermixture with races constituting free white persons. The Negro races referred to those are constituting free white persons. The Negro race is referred to being those from which the emancipated slaves of the United States descend. And this ex parte Shahid. Color. The word also means the dark color of the skin showing the presence of Negro blood, and hence it is equivalent to African descent or parentage. Colored has 3 definitions. By common usage in America, this term, in such phrases as colored persons, the colored race, colored men, and the like, is used to designate Negroes or persons of the African race, including all persons of mixed blood descending from Negro ancestry. But where a state constitution provided for separate schools for the white and colored races, the term white race was held to be limited to the Caucasian race, and the term colored races to embrace all other races. It has been held that there is no legal definition, or there is no legal technical definition, signification to the phrase colored person, which the courts are bound judicially to know. Black. Several different definitions from various areas of the Code of Federal Relations, CFR. 10 CFR 1040.3, black, not of Hispanic origin, a person having origins in any of the black racial groups of Africa. Black or African American, a person having origins in any of the black racial groups of Africa. Black, not of Hispanic origin. Black, not of Hispanic origin. Black or African American. Black, not of Hispanic origin. Black and not of Hispanic origin. Black, all persons having origins in any of the black African racial groups not of Hispanic origin. So these are all the CFRs that have black as mentioned in the Code of Federal Regulations. As you can see from the above definitions, almost every single term you could possibly use has some pitfall of being made to mean African in nature, but it began to become so vague that it became in some places to mean literally every race that is not white. This is why this subject is so confusing, because even terms like colored or black could mean of African descent, which would make you a U.S. citizen and not a state citizen or Indian. It may be interesting to know how someone was determined in the courts to be a free white person or Negro. They did not have DNA testing back then. I typed this into Grok and got quite an interesting answer, which you can see here, and he's going to share it. So let's take a look. How people were determined to be free white person. Let's see. Oh wow, that's that is quite extensive. Before the slaughterhouse cases of 1873, the determination of whether someone was a free white person or classified as a Negro in the United States was primarily a matter of state law, local custom, and judicial interpretation. There was no uniform federal standard for citizenship or racial classification until after the Civil War. The process was rooted in a combination of legal, social, and pseudoscientific practices that varied across states and regions. Below is an explanation of how these classifications were typically established. State laws, court determinings and proceedings, federal context and Dred Scott, social and cultural practices and challenges and ambiguities, and then translation of the slaughterhouse cases and beyond. So I'm not going to read all that because we still got a lot to read. So you guys can go check that out if you want. You guys know where to find all this stuff. A treatise on the word person. Looks like the end of section 9. So this entire nightmare is essentially born out of this enslavement of the Africans mentality that America has had since its very inception. Section 10, definition of the term individual. We're halfway there, guys. I'm going to take another sip of water because, boy, howdy, this is crazy. Ooh, hang on, guys. I got to shut the door because there are flies entering my domicile. And as much as I love flies, I actually don't love flies at all. So we're going to close that and just hope that they kind of fly into the bug zapper at some point and do kill themselves. And also, I have a assistant fly zapper here that I can get them with. All right. Definition of the term individual. At this point, it would be a good point to backtrack to the definition of individual. Let's look at the various definitions we can find. 1 USC subsection 8 is entitled person, human being, child, and individual, is including born alive infant, and says the following. In determining the meaning of any act of Congress or any ruling, regulation, or interpretation of the various administrative bureaus and agencies of the United States, the word person, human being, child, and individual shall include every infant member of the species Homo sapien who is born alive at any stage of development. As used in this section, the term born alive with respect to a member of the species Homo sapiens means the complete expulsion or extraction from his or her mother of that member at any stage of development, who after such expulsion or extraction therein, or extraction breathes or has a breathing heart, pulsation of the umbilical cord, or definite movement of voluntary muscles, regardless of whether the umbilical cord has been cut, and regardless of whether the expulsion or extraction occurs as a result of natural or induced labor, cesarean section, or induced abortion. Sure does sound like a whole shitload of words for something that should be simple, right? Yeah, well, that's the game. You think, oh, well, an individual is so simple. It's me. Yeah, it's not. Your umbilical cord and placenta, according to the above definition of live birth, were both independent live births. So let me ask you, who is on your birth certificate? Is it your body? Is it your umbilical cord? Is it your placenta? Are you even your body? Or are you just a consciousness that can be separated from a physical body? Could it be something else entirely? You assume that it's you on the birth certificate, but that would be unconstitutional in itself. So the question becomes, who are they referring to? If the words were really that simple, then they would be that simple in definition. The fact that they are not is evidence there is more here. Let's look at more definitions of individual. In 5 U.S. Code subsection 55(2) alpha part 2, individual is defined as the term individual means a citizen of the United States or any lawful alien admitted for permanent residence. We've already established that a U.S. citizen is a released slave of African descent, Negro, and that someone with a residence is an immigrant or foreigner. So let's rewrite this definition in English. The term individual means a Negro or legal fiction lawfully admitted to stay here as an immigrant or foreigner. And bingo, that is correct. So the term individual means Negro or legal fiction lawfully admitted to stay here as an immigrant or foreigner. So let's plug that same idea into the definition of the term person from the tax code, which is the term person shall be construed to mean and include an individual, trust, estate, partnership, association, company, or corporation. So let's rewrite that with the above info now. The term person shall be construed to mean and include a Negro, trust, estate, partnership, company, or corporation. Bam. So this is what a person means in the tax code: is freed black slaves and their descendants, trusts, estates, partnership, association, companies, and corporation. So there you go. So bingo, now we got it. I also personally believe that individual is typically referring to a sole proprietorship. So personally, I would say that the word individual leans to mean more of a sole proprietorship, whereas a natural person would lead more towards a Negro, but you get the idea. Mr. Miller actually explains how something like the sole prop even exists in the slaughterhouse cases. If all roads lead to Rome, slaughterhouse would truly be Rome itself. Here is what Mr. Miller has to say. That wherever a legislator has the right to accomplish a certain result, and that result is best attained by means of a corporation, it has the right to create such a corporation, and to endow it with the powers necessary to effect the desired and lawful purpose, seems hardly to admit of debate. The proposition is ably discussed and affirmed in the case of McCullough v. State versus Maryland. In relation to the power of Congress to organize the Bank of the United States to aid in the fiscal operations of the government. If I had to even go a step further with all this in mind, I would define person as the term person shall be construed to include any man, woman, child, or legal fiction with rights and obligations under the 14th Amendment. A Negro was never considered part of the people. They were considered property. This is how we wound up with this crazy situation. Now everyone is essentially considered property under the federal government and Congress because we tell them so. The state citizen category has essentially quietly been wiped away. Essentially, everyone has become Negroes without even realizing it, and this is like what's happened to our country. So let's use Grok on X. On January, February, March, April. On April 7th, I typed into Grok, how many times in Title 8 of the U.S. Code is the term individual used together with the term alien? Here's the answer it gave me. Estimation, the term alien appears hundreds of times in Title 8, and individual likely pairs with it in 50 to 100 instances based on procedural and definitional sections. Now, it would make perfect sense in many ways because a business is created under the United States, which is only and explicitly the District of Columbia per 4 USC 71. Actually, we're going to look that up right now because that's important. So check this out. All of that part of the territory of the United States included within the President District of Columbia shall be the permanent seat of government of the United States. So what does that mean? The United States is the District of Columbia. So anytime you see the United States, what it means is District of Columbia. So there you guys go. And that's how you look it up. 4 USC subsection 71. Anytime that you see created under the United States, like it doesn't mean the land mass. It doesn't mean like all that stuff. It means the corporation that is the United States that exists within District of Columbia. Or excuse me, not corporation. Let me backpedal a little bit. Anytime you see United States, it means District of Columbia in like the code. So there you go. And it would always be an immigrant as a person in each of the 50 states of the Union. So because it's from the District of Columbia and it goes to any of the other 50 states of the Union, it would be an alien individual or an individual alien. So a Negro would always be an immigrant or foreigner in any of the 50 states of the Union. They never had the right to be a state citizen and can only be U.S. citizens, which is under the federal national government, which would be the District of Columbia. They're essentially citizens of the District of Columbia. So as far as I'm concerned, this fully clarifies the definition of the word person in a new way that no one has ever discovered. You could almost go so far as to define an individual or person to be a Negro or legal fiction that was born or created in District of Columbia or subjects itself to the District of Columbia and would be an immigrant, foreigner, guest, meaning a resident in any of the 50 states of the Union. So again, guys, if you declare yourself a resident, you're saying, I'm a Negro or a descendant of a Negro that used to be a slave in the United States, right? And I am a guest inside of this state. If you're a free white state citizen, then you can domicile in that state. If you're a resident, you're just here temporarily, you're visiting, right? And Congress has authority over you. This is exactly why you can never find a definition of individual. Everything is carefully and explicitly defined except this word because they don't want you to know, and there's no way to define it without giving up the scam. P.S. Another important thing to keep in mind is that you become a ward of the court whenever you take on an attorney at law as a client. You can learn more about this on the Williams & Williams questions and answers page. A ward of court is an infant or person of unsound mind. This is another way that you become an individual as a white man. Section 11, the beginning of the administrative state and the replacing of the constitutional republic. Hooray! By the beginning of the 20th century, we see the beginning of everything that we see today. Every overcomplicated body of law that supposedly controls and specifies every area of our existence. The only major issue with this is that they always use the word persons and never people, which presumes that everything they are writing is under the 14th Amendment, which has absolutely nothing to do with the free white people who are state citizens of the Union. So what the hell happened? Did they begin to build an entirely new country, essentially on the heels of the 14th Amendment? Well, yes, the southern states literally had to in order to re-enter the Union. Every single mention of or definition of U.S. citizen after 1873 meant an entirely new classification, which were citizens of the District of Columbia. Which, keep in mind, prior to this point, anyone born in the District of Columbia had no right of citizenship of a state unless their parents specifically mentioned that they were citizens of a state of the Union and were not under the jurisdiction of the District of Columbia at the point of birth or conception. This was a complex situation, and now we sit here in our high horse thinking how things are or were, but we need to realize that at this time they did not have the luxury of evaluating this information the way that we do. Here we are many years later saying, oh, yes, they misunderstood. Well, we have our ChatGPT, Grok, Uber Eats, et cetera, et cetera. I really think they tried their best to sort all this out, and it simply wasn't good enough. Now we're the ones that need to pick up the pieces and clean it up. Section 12, the ultimate presumption. Personally, I believe that we follow a simple line of reasoning. We know everything, yet we dumb ourselves down and decrease our understanding in an effort to have something to do, something to learn, or something to understand. I believe we are all capable of complete understanding, but we're bored. We do not like the idea of understanding everything or having a verbose clarity on things because that ruins it all. It ruins our ability to understand the current scene and to relate that current scene to what gives us excitement and clarity. I don't typically share my opinions on most things because it's essentially irrelevant, but I believe we are simply consciousness that are capable of creation and art, and we drift from body to body between lifetimes and experience amnesia due to shame and guilt. I realize this may be a bit extreme, so I'm just being transparent. So if this is true, then we are impossible to truly destroy, but we crave the illusion of oblivion because we want a high stakes game. This is what we are unconsciously doing, in my opinion. Please don't attempt to argue with me on this. It's a waste of time. You're also entitled to your opinion, and we should honestly be more willing to talk about and have friendly debates on our opinions. This is how the courts should be operating. It should be a venue for us to have these conversations in a structured manner. We're walking a tightrope, meaning we want the mystery of the unknown without letting things fall into a complete oblivion. I have no idea how this word persons was so grossly lost in terms of its meaning in general, specifically in relation to that first line of the 14th Amendment. But here we are, and now it appears unbelievable that this is the true source of all the issues in America. Well, at least I believe it is. It clearly is. The ultimate presumption is that you are a Negro, and that presumption is solidified by you answering yes to questions like being a U.S. citizen or resident. Negroes released by the 13th Amendment and given a special citizenship through the 14th Amendment are always either a U.S. citizen or a resident when it comes to one of the 50 states of the Union. Being a U.S. citizen or resident means you are not really an American within what you think that classification is composed of. It is impossible to be a U.S. citizen resident and an American at the same time. You must willingly choose one or the other. And since you are not technically forced to choose either one, your choice to forego your American roots and decide to classify yourself as a Negro or U.S. citizen is considered voluntary. A white state citizen would be domiciled in his state, not a resident. People are simply choosing to be not true American without actually knowing what they're doing, and this is the entire conversation. Section 13, the incorporation doctrine. The Cornell Law page, where I will put most of the important information for this section, can be found at law.cornell.education, incorporation doctrine. We're going to actually take a look at that right quick because the incorporation doctrine is pretty cool, where it talks about like which of the amendments are incorporated. So like of the first 10 amendments in the Bill of Rights, the First Amendment, the right to indictment by grand jury trial has not been incorporated. Or, excuse me, the First Amendment has been fully incorporated. So is the Second Amendment, so is the Fourth Amendment, so is the Eighth Amendment, right? So you have the First, the Second, the Fourth, and the Eighth completely. You have the partial of the Fifth Amendment. You do have the right to indictment by a grand jury. And then the Sixth Amendment, the right to jury selected from residents of crime location has not been incorporated. And then you have no incorporation on the Third Amendment or on the Seventh Amendment. So the First Amendment, you have the guarantee against the establishment of religion. You have the free exercise of religion. You have freedom of speech, freedom of the press, freedom right of assembly and petition, freedom of expressive association. On the Second Amendment, you have the right to keep and bear arms from McDonald v. Chicago. This was in 2010, by the way. That's when it got added, so it's pretty fucking recent. The Third Amendment is not incorporated. That's the one to quarter soldiers in your home. The Fourth Amendment, you have freedom from unreasonable search and seizure, and there's requirements for warrants. The Fifth Amendment, you have the right to indictment by a grand jury. You have no double jeopardy. You have the right against self-incrimination, and you have protection against taking property without due compensation. The Sixth Amendment is partially incorporated. You have the right to a speedy trial, right to a public trial, right to an impartial jury, right to notice of accusations, right? Notice of accusations. Bam. That's something important. If they say like, we accuse you of this, that, or the other thing, like they can't just arrest you without giving you notice. You have the right to confront hostile witnesses. You have compulsory process to obtain witness testimony. You have the right to confront favorable witnesses. You have the right to counsel. You have the right to jury selected from residents of the state and district where the crime occurred. Is not incorporated. Just kidding, you don't have that one. The Seventh Amendment, not incorporated. The Eighth Amendment, protective against excessive bail, protective against excessive fine, and protection against cruel and unusual punishments. So there you go. That's your incorporation doctrine. But that's enough of that. We're getting off track here, and we've still got a lot to go. So, Section 13, the incorporation doctrine. Throughout the years, later after slaughterhouse cases, we have what is called the incorporation doctrine. This is essentially where they were trying to build back all the original rights that were for white citizens back into the U.S. citizen category. Cornell law describes it like this. The incorporation doctrine is a constitutional doctrine through which parts of the first 10 amendments of the United States are made applicable to the states through due process clause of the 14th Amendment. Prior to the doctrine's existence, the Supreme Court found the Bill of Rights to only apply to the federal government and to federal court cases. During the signing of the Constitution, every state in the negotiation had different levels of concerns with a too powerful federal government. And the preamble to the Bill of Rights highlights the importance of the Bill of Rights in limiting overreach of the newly created government. The Supreme Court noted that the Bill of Rights was clearly intended to limit only the federal government. States and state courts could choose to adopt similar laws, but were under no obligation to do so. After the passage of the 14th Amendment, the Supreme Court, through a string of cases, found that due process clause of the 14th Amendment, including applying parts of the Bill of Rights of states, referred to as incorporation. A lot of contention surrounds whether the 14th Amendment should incorporate any substantive rights, with opinions from the Supreme Court justices ranging from complete to no incorporation. Rather than find that due process clause incorporates all of the Bill of Rights, the Supreme Court supported selectively incorporating rights that the court finds as essential to due process. Under selective incorporation, the Supreme Court incorporated certain parts of certain amendments rather than incorporating an entire amendment at once. Some argue that the Privileges or Immunities Clause is a more appropriate textual basis than the Due Process Clause for incorporation of the Bill of Rights, but because slaughterhouse cases dealing with this clause are surrounded by controversy, this theory is not supported by the majority of the court. As a note, the 9th Amendment and 10th Amendment have not been incorporated, and it is unlikely that they ever will be. The text of the 10th Amendment directly interacts with state law, and the Supreme Court rarely relies upon the 9th Amendment when deciding cases. As you can see, the above is a clear and excellent description of what this is. Here is a copy and paste breakdown of each of the original 10 points that the white men had and their corresponding cases which incorporated or deemed them unable to be incorporated. The original state citizen rights into privileges and immunities available for the Negroes of the 14th Amendment. The 9th and 10th Amendments were never incorporated, so only 8 remain. Here's the fully ones. We just covered that. Boom. Second Amendment, Third Amendment, not incorporated, which, by the way, the Third Amendment, it's a very strange one to have not incorporated. Prohibits the government from forcing citizens to house soldiers in their private homes during peacetime. So, I don't know. I don't know why that one's not incorporated. That's interesting. And then, we covered all this. We did not cover the 7th Amendment. Let's take a look at what the 7th Amendment is. Those of you guys that don't remember, guarantees the right to jury trial in federal civil cases involving disputes over property of money valued at more than $20. I can see why they didn't incorporate that. All right, in the 8th Amendment. Boom. Look, here we go. Time for more water. My goodness. There was also another case I wanted to show you that describes many of these rights being converted into privileges and then added in on the U.S. citizen side of the equation. And that's from Twining v. New Jersey. This case was later overturned by Mallory v. Hogan, but this case is still widely important because it breaks down the historical timeline of all the various cases and things that happened up to 1908, involving all this information about the differences between U.S. citizens and state citizens. This quote is talking about what rights U.S. citizens have versus state citizens. Some of this information is outdated and should be compared to the above incorporation doctrine cases for reference. So let's see what he has to say. Thus, among the rights and privileges of national citizenship recognized by this court are the right to pass freely from state to state, the right to petition Congress for a redress of grievances, the right to vote for national officers, the right to enter the public lands, the right to be protected against violence while in the lawful custody of a United States Marshal, the right to inform the United States authorities of violations of its laws, the right to trial by jury in civil cases guaranteed by the Seventh Amendment, the right to bear arms guaranteed by the Second Amendment, have distinctly held not to be privileges and immunities of citizens of the United States guaranteed by the 14th Amendment against abridgment by the states. And in effect, the same decision was made in respect to the guarantee against prosecution, except by indictment of a grand jury, contained in the Fifth Amendment, and in respect of the right to be confronted with witness, contained in the Sixth Amendment. So this is essentially the world that we've been living in. We are all self-proclaimed persons, meaning Negroes, under the 14th Amendment, and these various rights have been incorporated into the 14th Amendment. But there's a problem. We're all pretty aware about how the world actually works, and it's often where these various incorporated rights don't work like you would think they would. Well, it's quite simple, and the Honorable Justice Taney already told us why they previously in Dred Scott v. Sanford. Again, I will use bold and underline to bring your attention to specific areas in the quote. The question before us is whether this class of persons described in the plea abatement to compose a portion of this people and are constituent members of the sovereignty. We think they are not, and that they are not included and were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. On the contrary, they were at that time considered as a subordinate inferior class of beings who had been subjugated by the dominant race. And whether emancipated or not, they yet remained subject to their authority and had no rights or privileges but such as those who held the power and the government might choose to grant them. So as you can see above, these incorporated rights are not really rights. They are exactly what they say they are: privileges and immunities under the 14th Amendment. The Bill of Rights is essentially a gift that is being given to the U.S. citizens from Congress, and it has nothing to do at all with the Constitution. Meaning, Congress doesn't need to give their citizenship class any of the Bill of Rights if they don't want to. Their citizens do not have a right to the Bill of Rights. It's a privilege given by Congress. Here's the definition of privilege: a special right, advantage, or immunity granted or only available to a particular person or group. This was made crystal clear in a case from 1968, United States v. Valentine, where the Honorable Justice Chief Judge Clement Nascimento Candelas said, "The only absolute and unqualified right of citizenship is to residence within the territorial boundaries of the United States. A citizen cannot be either deported or denied re-entry." Bingo, that is exactly correct. U.S. citizens, meaning Negroes, only have one right, and they have many optional privileges, immunities, but you only have one single guaranteed right: that you cannot be deported or denied re-entry into the. So like you're literally like if you are a self-proclaimed person, a person under the 14th Amendment, a freed black slave or Negro or whatever you want to call it, then you only have the right to not be denied re-entry into the United States, and you can't be deported. So, people under the protection of the 14th Amendment can't be deported. 1968, U.S. v. Valentine. There you go. That is the only right. So if you have yourself classified as a U.S. citizen or a resident or permanent resident of a state, the information in this section carefully breaks down your situation. This may shed quite a bit of light as to why this country is the way it is. I imagine now it's starting to make a lot of sense. The question that the government is essentially asking you all the time is, are you a Negro? And you're saying yes. And what's so shocking is that no one on either side of that question actually understands the question. Everyone is ignorant, and we're in an unthinking nightmare. The people asking the question don't fucking know. The people answering the question don't fucking know. And yet the situation exists as it does. Sorry, buddy. You got to die, Mr. fucking Mr. Moth. All right. So yeah, the government just asking everyone, are you a Negro? They don't know they're asking that. We don't know they're asking that. We're answering it, and we all fall under this really shitty like class and categorization. A permanent resident is someone who simply has their citizenship, meaning alliance and subjugation, somewhere else and has decided to stay here in a foreign land without becoming a state citizen. You can see this defined in 8 USC 1101A20. The term lawfully admitted for permanent residence means the status of having been lawfully accorded the privilege of residing permanently in the United States as an immigrant in accordance with the immigration laws, such status not having changed. As a resident, your citizenship is not defined in that term. It is simply known that your citizenship is not in that area. It is simply assumed by the term that your allegiance and subjugation lies elsewhere. A Negro can never complete the naturalization process due to him not being a free white person, so he can only become a permanent resident of a state or of the United States. What's amazing is that literally all this chaos and insanity was caused due to one single misunderstood word, the word persons in the first section of the 14th Amendment. Too wild to even be believed. All right. Section 14. Using anything derived from the 14th Amendment automatically makes you a Negro. So what makes this so complex is that in court, the basic fundamental question for almost anything going on is like this: duty, breach, damages. In law, this is called a cause of action. A cause of action is essentially the basic breakdown of a specific claim on a complaint. For example, a cause of action for breach of contract would be they had a duty to perform based off contractual obligation. This contract is then attached to the claim or complaint as evidence as an exhibit. 2, someone breached that claim, ideally with attached evidence proving the alleged breach. 3, damage occurred due to this breach with the attached evidence or affidavits proving that the damages that resulted. So basically, like, somebody had a duty, somebody broke the duty, the breaking of the duty caused the damage. There you go. That's in law, this is what's called a cause of action. This, in essence, is the composure of a cause of action, and then the one or more cause of action comprise a complaint, and that is really quite simple. Now, here's the issue. If you use anything as a cause of action which comes from the 14th Amendment, you are, in essence, classifying yourself as a Negro by doing so. I'll give you an example. Let's look at 42 U.S. Code 21, entitled Civil Rights are for whites and rights are for the whites and civil rights are for the Negroes. You can see how the obvious situation is in 42 USC. Ooh. Oh, okay. So 42 USC is entitled Civil Rights. Let's take a look at it. We're going to actually do that here live. Civil rights. Okay, so civil rights mean rights for the Negroes, right? And then regular rights are the term for the white state citizens, or the whites that, like, the Constitution was originally written for, that America was originally like defined by. So there you go. Okay, I have to continue. Shout out to those of you guys on X, by the way. I know there's no one on YouTube, and I don't blame you. This is long and detailed, but I have to read this. So here we go. You can see how obvious the situation is in 42 USC subsection 1981. I was in underline showing the key parts. All persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts, to sue, to be parties, give evidence, and to the full and equal benefit of all laws and proceedings for the security of persons and property as is enjoyed by white citizens, and to Actually, we're going to search that up too. Statement of Equal Rights. All persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts, sue and be parties, give evidence as it is enjoyed by white citizens. Wow, look at that. There it is again. A person has the same right as white citizens. There you go. Bazinga. It's right there in front of us, like this whole time, guys. It's totally nuts. And shall be subject to like punishment, pains, penalties, taxes, licenses, and extractions of every kind, and to no other. And in 42 USC 1892, we see the following wording, where again I'll underline to bring to your attention a couple of areas. All citizens of the United States shall have the same right in every state and territory as is enjoyed by white citizens, thereof to inherit, purchase, lease, sell, hold, and convey real and personal property. Now, all this is highly important because two of the most common statutes used in civil cases when their rights are violated are 42 USC 1983 and 42 USC 1985, which are right after the above. So everyone bringing claims or causes of action under 42 USC 1983 or 42 USC 1985 are using the Negro Civil Rights Code. So thus, the obvious presumption is that you must be a Negro. This is the issue. Now, keep in mind that the government did give you a sole proprietorship, which is simply just your name in all caps. That is the persons that is actually a 14th Amendment citizen. You can prove that easily because when you look up who can get a social security number in 22 CFR 422.104, you will see that you need to be a U.S. citizen, which is Negro or Negro fiction, in order to have one. So you have a U.S. citizen called a sole proprietorship, which is under the 14th Amendment. And this is exactly how you can bring a claim under 42 USC 1983 or the other one. But you as a free white man or state citizen or actual American absolutely may not do so. So how would you navigate something like that? Easy. Just make your sole proprietorship as a person, the plaintiff in the lawsuit, and you become the attorney in fact or next friend on behalf of that person. In this way, you can still bring your claims without committing a felony by saying that you are a Negro when you are not, which can put you into prison up to 3 years according to 18 USC 911. Let's take a look at that. It's a federal crime for anyone to falsely and willfully represent themselves as a United States citizen. Violating this statute carries severe penalties, including federal fines and up to 3 years in prison. So basically, if you say that you're a black person, then you can go to jail, or a Negro specifically. If you prefer to actually bring a claim yourself without some kind of persona or corporate fiction, as a white state citizen, I would recommend that you use your original state's constitution in state court or use the original Bill of Rights in federal court. Besides that, with anything else, you would need to check and see if it's derived from the 14th Amendment. Newsflash, almost every area of law is derived from the 14th Amendment. If you see the term persons anywhere, that's fucking everywhere, then you immediately know that you're looking at something derived from the 14th Amendment, speaking about Negroes and corporate fictions exclusively. Qualified immunity and the true source of systemic racism in America. Preface to this section. I truly believe that only a small percentage of the police force are intrinsically persons of ill intent. Legally, police officers are persons, not people, by the way. I'm not just saying that, that's an actual legal fact. But I do believe that the overall policing system is currently operating in a way that needs some serious adjustment. We just need to tweak the system, and all police officers will adjust to the way the system is adjusted. So the police are not the enemy, it's simply the calibration of the system itself. I'm also not excusing police brutality, but there is a middle ground here that needs to be acknowledged. Let's talk about qualified immunity. First, let's get a definition and start this section off with an article from the National Conference of State Legislatures, NCSL. I think it's a great starting place. The doctrine of qualified immunity protects state and local officials, including law enforcement officers, from individual liability unless the official violated a clearly established constitutional right. The evolution of qualified immunity began in 1871 when Congress adopted 18 U.S.C. subsection 1983, which makes government employees and officials personally liable for money damages if they violate a person's federal constitutional rights. State and local police officers may be sued under subsection 1983 Until the 1960s, few subsection 1983 lawsuits were successfully brought. In 1967, the Supreme Court recognized qualified immunity as a defense to 1983 claims. In 1982, the Supreme Court adopted the current test for the doctrine. Qualified immunity is generally available if the law enforcement official violated, or if the law a government official violated isn't clearly established. Now, at this point in this conversation, you already know where I'm headed with this. This only applies to men, women, children, and legal fictions, which has rights and obligations under the 14th Amendment. If you already saw that coming, great. That means you're learning. Thank Christ. Now, this gets more interesting because we can see this even more clearly by actually diving into the cases associated with the situation. Let's take a peek, shall we? I am not much of an AI guy, but I've recently been using Grok to find cases to dig into specific subjects. I typed into Grok, what main court cases establish qualified immunity for the police? And this is what it gave me. Pearson v. Ray. This is the first case to recognize qualified immunity as a defense for public officials, including public police officers. The court held that officers could be shielded from liability for constitutional violations if they acted in good faith and without clear knowledge that their actions were unlawful. Harlow v. Fitzgerald. This case defined the doctrine by establishing an objective standard for qualified immunity. The court ruled that officials are immune unless their conduct violates clearly established constitutional rights that a reasonable person would have known, removing the subjective good faith requirement. Anderson v. Crichton. This case further clarified that for a right to be clearly established, prior court decisions must have defined the right with sufficient specificity. It protected officers unless their actions were clearly prohibited by existing precedent. Saucier v. Katz. The court formalized a two-step test for qualified immunity, whether the officer's conduct violated a constitutional right, and two, whether that right was clearly established at the time. This rigid sentence was later made flexible in Pearson v. Callahan. Mullenix v. Luna. This case emphasized the high bar for overcoming qualified immunity, reinforcing that a right must be defined with particularity, not at a general level, to be considered clearly established. Now, at this point, most of you dumb fucks would start asking Grok more questions, and to summarize these cases for you and all other manner of worthless, pathetic bullshit. This is how we got into this situation in the first place. Obviously, no one fucking knows shit about any of this, otherwise we wouldn't have the fucked up situation we have. So don't be a worthless jackoff. Use AI to locate the cases, then actually take the time to go read them. Don't ask AI, which is an amalgamation of other person's misunderstanding and retardation of what these cases say. Let's head over to Google Scholar and look up the case Pearson v. Ray. Light up a cigar and take a look at the quotes that we can dig out of these things. These cases present issues involving the liability of local police officers and judges under subsection 1 of the Civil Rights Act. Now, 42 USC subsection 1983, petitioners in number 79 were members of a group of 15 white and Negro Episcopal clergymen who attempted to use segregated facilities at an interstate bus terminal in Jackson, Mississippi. More exciting quotes from the case. The evidence at the federal trial showed that petitioners and other Negro and white Episcopal clergymen undertook a prayer pilgrimage in 1961 from New Orleans to Detroit. The purpose of the pilgrimage was to visit church institutions and other places in the North and South to promote racial equality and integration, and finally to report to a church convention in Detroit. Letters from the leader of the group to its members indicate that the clergymen intended from their beginning to go to Jackson and attempt to use segregated facilities at the bus terminal there, and that they fully expected to be arrested for doing so. The group made plans based on the assumption that they would be arrested if they attempted to peacefully exercise their right as interstate travelers to use the waiting rooms and other facilities at the bus terminal. The letters discussed arrangement for bail and other matters relevant to arrests. So, bro, how can this even be real in 2025? I'm reading this and almost tears in my eyes thinking that this fucking dumb bullshit is now the bedrock to the reason how police have immunity. Qualified immunity is literally legal terrorism fueled by racism. You can see this. We've barely even started looking at this case and we can already comfortably make a determination. I recently had a very interesting comment on my YouTube channel by the username NT75 that I would like to share at the point in this discussion. The police is the modern form of the KKK. This comment really startled me and got me thinking. While I don't necessarily agree or disagree, intrinsically, the real issue is that the system itself is inherently fucked up and we need to fix the system, not the individual police officers. They obviously just have no clue what is going on. If we attack the individual officers, things will get worse, whereas if we attack the system itself, we can begin to see the honest and real long term change in this situation. We need to focus on the true enemy, which is the system, not the persons administering it. You guys might be mad about the situation, but knowing that all police are legally persons is actually quite a hilarious situation itself. They don't even realize that they have fallen into their own trap. They are legally Negroes who have been given the privilege to assault other Negroes with qualified immunity. This is the legal reality of the situation. Remember its privileges and immunities. Let's keep going on in this case. I want you to see how absolutely fucking insane the world you really live in is. Look at this next quote. The ministers stayed one night in Jackson and went to the bus terminal the next morning to depart for Chattanooga, Tennessee. They entered the waiting room, disobeying a sign at the entrance that it announced white waiting room only by order of the police department. They then turned to enter the small terminal restaurant where they were stopped, but were stopped by two Jackson police officers, respondents Griffith and Nichols, who had been awaiting their arrival and who ordered them to move on. The ministers replied that they wanted to eat and refused to move on. Respondent Ray, then a police captain and now the deputy chief of police, arrived a few minutes later, and the ministers were placed under arrest and taken to the jail. Let's stop again. Look, I'm from Indiana. I know racism. I get that all races sort of stick to themselves and prefer their own people. I get that. I really do. And I think racism is a fairly normal cultural behavior. But, bro, these are white and black ministers who are literally traveling around to preach acceptance in a peaceful way. I'm sorry, I don't care how left or right you are in a situation like this. This is absolutely insane. Imagine officers doing some shit like this in 2025. But I'm not down with it, bro. This is fucking insane and stupid and has no right being a basis for qualified immunity, but let's keep going. All witnesses, including the police officers, agreed that the ministers entered the waiting room peacefully and engaged in no boisterous or objectionable conduct while in the white only area. There was conflicting testimony on the number of bystanders present and their behavior. Petitioners testified that there was no crowd at the station and that no one followed them into the waiting room, and that no one uttered threatening words or made threatening gestures. The police testified that some 25 to 30 persons followed the ministers into the terminal, and the persons in the crowd were in a very dissatisfied and ugly mood, and that they were mumbling and making unspecified threatening gestures. The police did not describe any specific threatening incidents and testified that they took no action against any persons in the crowd who were threatening violence because they had determined that the ministers was the cause of the violence, if any might occur. Although the ministers were conceitedly orderly and polite, and the police did not claim that it was beyond their power to control the allegedly disorderly crowd. The arrests and convictions were followed by this lawsuit. Do I need to say anything? Obviously not. Let's continue. We find no difficulty in agreeing with the Court of Appeals that Judge Spencer is immune from liability for damages for his role in these convictions. The record is barren of any proof or specific allegation that Judge Spencer played any role in these arrests and convictions other than to adjudge petitioners guilty when their cases came before his court. Few doctrines were more solidly established at a common law than the immunity of judges from liability for damages for acts committed within their judicial jurisdiction. As this court recognized when it adopted the doctrine, this immunity applies even when the judge is accused of acting maliciously and corruptly, and it is not for the protection or benefit of a malicious or corrupt judge, but for the benefit of the public whose interest it is that the judges should be at liberty to exercise their functions with independence and without fear of consequences. It is a judge's duty to decide all cases within his jurisdiction that are brought before him, including controversial cases that arouse the most intense feelings in the litigants. His errors may be corrected on appeal, but he should not have to fear that unsatisfied litigants may hound him with litigation charging malice or corruption. Imposing such a burden on judges would contribute not to principled and fearless decision making, but to intimidation. Okay, fine, I can see that point of view. But don't you think there should be a little more of a discussion as regards to what is considered acceptable and what is not, rather than just a blanket immunity to treat Negroes and persons however they want? Again, none of this has anything to do with white state citizens. Even if they didn't realize that at the time, makes no difference. Let's keep going on the case. The common law has never granted police officers an absolute and unqualified immunity, and the officers in this case do not claim that they are entitled to one. Their claim is rather that they should not be liable if they acted in good faith with probable cause in making an arrest under a statute that they believe to be valid. Under the prevailing view, in this country, a peace officer who arrests someone with probable cause is not liable for false arrest simply because the innocence of the suspect is later proved. A policeman's lot is not so unhappy that he must choose between being charged with dereliction of duty if he does not arrest when he has probable cause, and being mulcted in damages if he does. Although the matter is not entirely free from doubt, the same consideration would seem to require excusing him from liability for acting under a statute that he reasonably believed to be valid, but that was later held unconstitutional on its face or appealed or applied. Okay, I get this concern, but none of this is applicable in 2025. Totally irrelevant. Do you think all the people in the place would scoff and be upset over white and black ministers using the whites only bathroom in 2025? That was a joke because the situation isn't even possible in 2025. I'm not going to keep banging this case or subsequent cases, but you can see the original cause of action was under the Negro Civil Rights Act. So all this stuff that happened because that makes perfect sense. They have absolutely no legal obligation to pay respect or to respect the privileges and immunities of Negroes. We've gone through a majority of that case, and now you can kind of see how my mind works and how I build my various cases. You can read other cases, then now build a claim or defense based on that information and file it in. Doing this stuff is actually really interesting and fascinating, and I wanted to kind of write this section as a little teaser to kind of show you how this can work and how it can be interesting discovery. It empowers you because you realize pretty rapidly that things like qualified immunity is complete horseshit, but you have to actually attack it in the proper way. As you can see, this is the true systemic racism in our country. This whole page could be called Systemic Racism in America, and you would actually be correct. Part 16, America, the world's Negro plantation. You need to be a U.S. citizen to be president. You need to be a U.S. citizen to serve on a jury. You need to be a U.S. citizen to be a governor of a state, which immediately proves that it's not an actual state, but simply a federal corporation called State of blank. A U.S. citizen is absolutely not able to be the governor of the actual state. And what makes it even more complex is that the state itself is a U.S. citizen. A Californian would be the only person able to be the governor of California. A Texan would be the only one able to be the governor of Texas, etc. A U.S. citizen is someone, an individual organization, that has pledged their allegiance to and have subjected themselves to the District of Columbia, which is not one of the states of America. How could a citizen of the District of Columbia be a governor of a sovereign state like California? That's insane. It's 14th Amendment citizenship for released Negroes after the 13th Amendment released them from slavery. Now, I said it a million times, but keep saying it so it can have some time to sink in. Are you seeing the big picture here? There's literal evidence that the state of California is not a part of the actual state. Here's the fun part. It's a public corporation on behalf of the District of Columbia. The state of California has a fucking EIN number, 94-600-1347. It is literally just a business on behalf of the District of Columbia, and everyone who works for it on paper are blacks of African descent. The people of state of California is impossible. It can only be the persons of state of California. State of California never replaced the actual California. Same for all the other states. This is obvious by the fact that you need to be a U.S. citizen to be a governor of state of California. That means the entire original de jure government is just sitting there empty. Excuse me. For example, the 1849 California Constitution is the original Republican center of the original American state. California, meaning the political body which comprises the sovereignty, has a constitution from 1849 that has never been expressly canceled or replaced. Even AI will tell you that. So America is literally one giant cotton plantation for Negroes. Everyone is black and of African descent on paper. The whole country operates as though it was released from slavery from the 13th Amendment and given citizenship through the 14th Amendment. The whole country operates as though America began in 1868, not in 1776. This isn't even a joke or something funny or cute. This is literal and not a joke at all. I hope you can see this. It's quite shocking and eye-opening. It's honestly really sad. Section 17, two classes of citizens and two distinct constitutions. There are so many articles online in this law space talking about how one constitution is of the United States and the other is for the United States. Some people even say that the second constitution is invisible. This is all silly and the situation is simple. quite simple to figure out. First, we need to start with the legal definition of constitution. The organic and fundamental law of a nation of a state, which may be written or unwritten, establishing the character and conception of its government, laying the basic principles to which its eternal life is to be conformed, organizing the government, and regulating, distributing, and limiting the function of its different departments, and prescribing the extent and manner of the exercise of sovereign powers. A charter of government deriving its whole authority from the governed. So, as we can see, a constitution is basically the contract or set of rules for a nation or state. Since we have two entirely different classes of citizenship, we obviously have two separate constitutions. But what are they? Let's return to the most important case that has ever occurred since the dawn of our country, slaughterhouse cases, and hear from Mr. Miller with more quotes to clean all this up for us. In light, my quotes will not be in bold and will be in brackets. In light of the history of these amendments and the pervading purpose of them, which we have already discussed, it is not difficult to give meaning to this clause. The existence of the laws in the states where the newly emancipated Negroes resided, which discriminated with gross injustice and hardship against them as a class, was the evil to be remedied by this clause, and by it such laws are forbidden. If, however, the states do not conform their laws to its requirements, then by the 5th section of the Article of Amendment, Congress was authorized to enforce it by suitable legislation. We doubt very much whether any action of a state not directed by way of discrimination against the Negroes as a class or on account of their race will ever be held to come within purview of this provision. It is so clearly a provision for that race and that emergency that a strong case would be necessary for its application to any other. But as it is a state that is to be dealt with, and not alone the validity of its laws, we may safely leave that matter until Congress shall have exercised its power, or some state oppression, by denial of equal justice in its courts, shall have claimed a decision at our hands. We find no such case in the one before us, and do not deem it necessary to go over the argument again, as it may have relation to this particular clause of the amendment. So we can see here that Mr. Miller is going into even more depth, showing that U.S. citizen category was created as a separate class and placed under federal care so that the released Negroes as foreigners in a state are not going to be discriminated against by the states. So in this respect, we need to think as to how there could be two constitutions. Well, we have the original Constitution, which is for the white state citizens. That Constitution is the one for United States of America. We're going to switch camera styles because you guys don't need to read along with me. That'll probably bore you. So there we go. And should be classified as a constitution. So in this respect, we need to think how there could be two constitutions. Well, we have the original Constitution, which is for white state citizens. That Constitution is one for the United States of America. Now we have to think, what is the document that basically breaks down all the rights and rules for U.S. citizens and could be classified as a constitution for that class? Well, the only thing it could be is the 14th Amendment. There is no other document, and Mr. Miller is clear in the following quote about how the 14th Amendment has nothing to do with state citizens and cannot claim any protections under the 14th Amendment. Of the privileges and immunities of the citizens of the United States and of the privileges and immunities of the citizens of the state, and what they respectively are, we will presently consider. But we wish to state here that it is only the former which are placed by this clause under the protection of the federal Constitution, and that the latter, whatever they may be, are not intended to have any additional protection by this paragraph of the amendment. So yes, there are two constitutions, but I don't think one is for and the other is of, nor do I think the second constitution is invisible or unwritten. It's simply the 14th Amendment. Section 18. Information versus grand jury indictment, the destruction of due process in America. A grand jury indictment is the exercising of the white state citizen's due process. A member of the sovereignty, meaning a white state citizen, can only be judged by a panel of people from the same political body, meaning white state citizens. This is a very simple concept. The government or a corporation may not express justice by itself, but needs that grand jury in order to exert justice to the political body which compromises the sovereignty, meaning white state citizens. State citizens created the government, and thus they are above it. And the government may only express the judicial process once a body of that sovereignty, called the grand jury, approved that it take place. Obviously, a U.S. citizen is not a member of the sovereignty, and so there was a case that expressed the situation, which is Hurtado v. California, U.S. Supreme Court, 1884. This case is where it made clear from the Supreme Court that an information could be used instead of a grand jury for criminal charges. What is an information? Well, it's essentially a charge that is filed by a prosecutor rather than a grand jury of state citizens. You'll hear judges say things like, the court has an information before it alleging, you are charged by way of information, etc. This shows that the defendant is being charged from the state or government prosecutor, not through political body of the sovereignty. This, right away, is evidence that the presumption is that the defendant is a U.S. citizen under the 14th Amendment, because that is the only way that someone can be charged via an information. If you do not rebut this presumption, then it stands as truth in law. Let's review some of the quotes from the above case, Hurtado v. California. I'll center and bold the quote, and then we'll talk about it below the quote. It is claimed on behalf of the prisoner that the conviction and sentence are void on the ground that they are repugnant to that clause of the 14th article of amendment of the Constitution of the United States, which is in these words, nor shall any state deprive any person of life, liberty, or property without due process of law. So right away, alarm bells should be blaring in your minds as regards to the situation. The entire basis of the original claim by the person bringing this case is a 14th Amendment claim, which right away shows us that this is a claim that is exclusively functional under U.S. citizenship class and is not a white state citizen claim. Now, keep in mind the Second California Constitution had just been ratified in 1879. So this is right after that, on top of the slaughterhouse cases and the 14th Amendment. So this is all happening right around the same time. Let's take a look at more quotes on this case. And in Walker v. Savinet, the court said, a trial by jury in suits at common law pending in state courts is not therefore a privilege or immunity of national citizenship, which the states are forbidden by the 14th Amendment to abridge. A state cannot deprive a person of his property without due process of law, but this does not necessarily imply that all trials of the state courts affecting the property of persons must be by jury. This requirement of the Constitution is met if the trial is had according to the settled court of judicial proceedings. Due process of law is process according to the law of the land. This process in the states is regulated by the law of state. When they are talking about a privilege or immunity of national citizenship, they are talking about the U.S. citizen classification. So this is entirely true. U.S. citizens have no right to trial by jury. If you go back up and review the incorporation document, you will see that even to this day, the 7th Amendment, which is your right to trial by jury, has never been reincorporated in for U.S. citizens. There are not many other quotes on this case, but we've done plenty to show you how this whole information thing is terribly flawed and would apply to white state citizen. A white state citizen cannot be charged with an information, and any attempt to do so should be met with an immediate motion to dismiss for lack of jurisdiction. Again, a white state citizen cannot be charged with an information, and any attempt to do so should be met with an immediate motion to dismiss for lack of jurisdiction. I'm going to copy that because that would have been very useful during the well, I mean, if Richard Hart cared to be a white state citizen, instead of a U.S. citizen. So let us see. Where can I put this? I'm going to put this in my notes. Bam. All right. The Holy Grail, the 9th and 10th Amendments. Bazinga. We're going to copy that and put that in the notes too. So anyways, by the way, guys, if you want to check all this stuff out, you can find a lot of it over in t.me/Pickletaria. So that's where a lot of this stuff lives and exists in my notes sections. All right. The Holy Grail, the 9th and 10th Amendments. As a white state citizen, meaning a non-U.S. citizen, the ultimate unlockable aspect of the law is the 9th and 10th Amendments, which, as you can see above, were never incorporated back into the Negos. The 9th Amendment is the enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Here's a quote from James Madison speaking about the 9th Amendment on June 8th in 1789 in a speech in the House of Representatives. It has been objected also against a Bill of Rights that by enumerating particular exceptions to the grants of power, it would disparage those rights which were not placed in that enumeration. And it might follow by implication that those rights which were not singled out were intended to be assigned into the hands of the general government and were consequently insecure. This is one of the most plausible arguments I've ever heard urged against the admission of a Bill of Rights into the system, but I conceive that it may be guarded against. I have attempted it, as gentlemen may see, by turning to the last clause of the 4th resolution, referring to what became the 9th Amendment. Here is an earlier version of the Ninth Amendment written by Madison showing more context behind what he was trying to do. The exceptions here or elsewhere in the Constitution made in favor of particular rights shall not be so construed as to diminish the just importance of other rights retained by the people or as to enlarge the powers delegated by the Constitution, but either as actual limitations of such powers or as inserted merely for greater caution. Here's the 10th Amendment. The powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively, or to the people. Here's a quote from James Madison, Federalist number 45 in January 1788. This was written during the ratification debates to explain the federalism structure that the 10th Amendment later codified. These powers dedicated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. The former will be exercised principally on external objects as war, peace negotiation, and foreign commerce, with which last the power of taxation will for the most part be connected. The powers reserved to the several states will extend to all the objects which, in the ordinary course of affairs, concern the lives, liberties, and properties of the people, and the internal order, improvement, and prosperity of the state. Now, hopefully, you can see obviously why these amendments were absolutely never incorporated back into the Negro civil rights. People running around thinking that the Second Amendment is so cool, but it's absolute trash compared to the Holy Grail, which is the Ninth and 10th Amendments. These amendments are only available to free white men and women who are not U.S. citizens, not Negroes, and not residents of everything. These amendments are only available for white state citizens who domicile in the state in which their citizenship lies. What the Ninth and 10th Amendments say, basically in English, is whatever you want your rights to be is totally fine as long as you aren't hurting anyone or lowering anyone else's standard of living. The Ninth and 10th Amendments are essentially all of common law. In a couple sentences, they are the most badass amendments ever. If you want your actual right to travel, well, here it is. The Ninth and 10th Amendment is the ultimate right to travel. Without needing a license to practice law, Ninth and 10th Amendment. Worried about growing and selling pot, Ninth and 10th Amendment. Just be careful about interstate commerce. Worrying about your rights to your children, Ninth and 10th Amendment. You get the point. By having access to these amendments, you become entirely immune to literally absolutely any aspect of law in which there is no victim and not clearly provable damages. Things like possession crimes, crimes without victims, paperwork-related crimes, all become legally impossible to prosecute. This is the ultimate true immunity. If you want true freedom in America, if you want to feel the bald eagles coursing through your veins, the Ninth and 10th Amendment is what you've been looking for. So here's how to shoot bald eagles into your veins. At this point, essentially for those who are all new to this information, you may be wondering how to change all this nightmare. It's pretty honest usually. If you were born in one of the 50 states of the Union, just get rid of all your businesses and licenses. Get rid of your driver's license. Only Negroes and aliens can have those. Shed everything that says U.S. citizen on it or resident or any of the other buzzwords. Operate your life through trusts. Do a federally registered trademark on your name in all caps through USTPO or USPTO. Stop saying you're a U.S. citizen or a resident. Then when it comes to your passport, you'll be getting a passport on behalf of your sole prop, meaning that your passport will have his date of birth on it, not yours, which is typically around 2 weeks after you're born. That's the date of the certificate of live birth is received and processed. This passport would become the only form of identification that you need. You can live a completely normal life system with just a passport. You can have bank accounts, credit cards, debit cards, checkbooks, all that stuff. You can do everything that you were doing before without losing any functionality or comforts in life. And that's it. It's quite easy. Free contract killer course will have a lot of information on all this, and if you want to learn more, you should sign up for it. It's free. You should also order a copy of his book called The Guide to the Most Beautiful Woman in the World, the United States of America. It's available on Amazon. Anyone who was naturalized into this country and they were not born here would simply need to follow the instructions in the Naturalization Act of 1802. Persons who do not fit the definition of free white person would not be eligible for citizenship. Also, persons who are born here of African blood would not be included. If that irritates you, then do something about it. Sue and get your case to the Supreme Court. Makes all proud. Fix and save the country. Man. Let's see. How far does this go? Oh, we're almost done. Bam. Okay. Thank God. If that irritates you, then fix it. You should get the slaughterhouse cases overturned or clarified. I know that I've been beating the drum for it to be overturned in a lot of my other content, but maybe it just needs some clarification. Because if it's simply clarified rather than overturned, then Negroes would not have the ability to become part of we the people, and they would be stuck as persons forever. This is not a choice for me to make, but is up to the people and persons in America to decide. I'm a believer in the American spirit, but keep in mind, statistically, white people make up a vast majority of the American population. So if the melanated persons or people want to make a change in how citizenship works, then they need to rise up and turn their entire culture into something that the white man can look at and be in agreement that they should be allowed to be included in we the people. The last comment That last comment may enrage some people reading it. Well, how's your program been working for you? We're all fucking slaves now. So obviously, whatever anyone has been doing and thinking is absolutely fucking abysmal horseshit. Otherwise, we wouldn't be here. To rise up and help the black race grow and become known far and wide is the most helpful. Friendly and contributing race would automatically make the black race the primary race, and the white people would actually become the minority. You don't see white people kicking the Asians out or doing shit to the Asian culture, out of this particular blip in times, anyways. So think about it. Any culture or race can become the dominant race by simply being badass and great in the eyes of all the other races in the world. Look at how people emotionally react to various races. Look at Samoans. People don't hate on them. In my opinion, which may offend some people, the black race has allowed itself to become infiltrated and destroyed from the inside. I think that's unacceptable, and we should all work together to fix that issue. I get that the situation is pretty fucked up, but sitting around and bitching about it has obviously not been very effective because look at the fucking septic shithole that we're currently laying in. Things aren't great. Doesn't take a rocket scientist to figure it out. We don't need more fucking dumbass retarded podcasts talking about it. What we need are solutions. Financial, legal, social, etc. These solutions will be made by thinking men who ignore all the racism and difficulties they may encounter and decide to make the pact to themselves that they will actually achieve their goals at all costs. Great historical figures such as Martin Luther King Jr. come to mind. This whole fucking world has become such a fucking pussy. No one's willing to die for anything anymore. What kind of pathetic fucking life is that? I didn't even realize I was alive until I had something I was willing to die for. Dred Scott is a great example of a man who should frankly be a shining star of what the black culture should be aspiring to. A fucking released slave at almost the height of the fucking Civil War, who wasn't even considered a fucking man. He was considered an article of property, and he had an intention, and he took that intention all the way to the fucking Supreme Court. It's pretty badass. A dude decided to do something against every fucking possible circumstance. That dude literally had the whole world fighting against him. That dude played a game under the most impossible odds that any fucking man or woman has ever seen. Odds that are so low that they don't even exist in today's world. Odds like a man with no legs winning a track Olympic medal, and he fucking stood up and did it anyways. If we had literally 3 Dred Scotts in today's world, I promise you, with the way things are now, this whole people person's bullshit would not be around much longer. But no, everyone's a fucking pussy who wants to get jerked off like little bitches. I'll consider myself a Dred Scott, the white version, obviously. And that's the world that we're in because we don't have more badasses like Dred Scott. I mean, in all cultures, including the white race. Will anyone can press these claims in court and advance through appellate courts and into the U.S. Supreme Court? Will it be you? I want to end this treatise by being absolutely and completely transparent about something. If the country decides to operate the way it's supposed to operate and decides as a country to not change and overturn the slaughterhouse cases of the 14th Amendment, what's going to happen is the country is going to split into 2 clear categories, just like it used to be. We, the people, will be the white state citizens under the Bill of Rights, and the Negroes will be persons under the 14th Amendment. All police will only be allowed to interact with Negroes. Sheriffs are for white people. And all white state citizens will have complete immunity from the police. White and black segregation will come back into this country, and that will make the mid 20th century look like a Disney film. It's not my job to make these decisions for our glorious country. My job is to dig up the truth, to organize it, and to parent it and present it in a way that can be understood so that us as a people and a presence, man, I gotta share this because yeah, we're just gonna have this up. So fuck it. This is a good section. My job is to dig up the truth. As a people and persons make educated and knowing decisions about our laws and existence. What occurs from this point forward depends entirely upon what you decide to do with this information. If the black race decides to do nothing as regards to this information, you are moving rapidly towards slavery coming back. And just like Mr. Taney said, it will be done for your benefit. Negroes will not be allowed to have gold and silver coins, which is the Gold Abrogation Act. They will need to have driver's license. They will need permits and licenses, and then the white people will not need to have any of that. This is the world we're steering towards unless we get some Dred Scott standing up and doing something about the situation. It's not my job to hold the dick of the black race and attempt to stop this from occurring. It's about transparency. If no one cares about sorting this out for the blacks or from the black race itself, then that's the self-esteem issue deeply embedded in black race, and I can't overcome that as a white man. Don't say I didn't warn you. You'll be in chains again, and there's not a goddamn thing I can do about it. I can't fight your battles for you. I'm simply trying to equip you and prepare you for the battle. If you decide not to show up for the fight, then you'll lose, and the future is already written. If the black race decides they're not going to fight for their right to be people, I will not personally own slaves, but I will also do nothing to prevent this from happening. I'm not the savior of the blacks, whites, or any other race. You paid me nothing to be here or read this. My job is completed by the writing of this. I have no further obligations. From here, people and persons needing to decide and act. The future of America is undetermined, and it's not my job to decide it. It's yours. And here's how to naturalize as a state citizen. So, boom. If you guys want to do that, then you can read this. So, bazinga. Very nice. This is how you can naturalize. Very cool stuff. So, ladies and germs, holy fuck, that's been a ride. It's been 3 hours. I'm super tired. My lymph nodes hurt. I think that a lot of this stuff in this treatise is good information. Oh, I should put on the proper background. I think a lot of the stuff in this treatise is good information. Do I agree with all of it? I think that it's some great opinion, and like I like to approach things with from a position of humility, and like I don't really know what I'm talking about. I don't really know what I'm doing, so I like to look at everything with an open mind. And I think that this made some really compelling, good arguments and good cases and good stuff. And I'm gonna follow in in this path of understanding. I might not probably be as bombastic as Brandon Joe Williams. Brandon, if you're watching, uh, cheers to you, homies. But like, I don't think that he got a lot wrong here, and he made some really good claims and drew some really good conclusions. So, for those of you guys that are interested in this stuff, it takes about 3 hours to read it. If you want to listen to this audio, I've got nothing else left. If you guys want to find more of the Degen Roundtable, you can catch us here live every Wednesday, Friday, and Sunday at 8 p.m. Eastern. I'm going to be up here in Colebrook, New Hampshire, and that's what we've got going on. So I hope you guys are doing a great time. And with that, ladies and gentlemen, I want to thank you all for spending your valuable time with us here on the Degen Roundtable. As Agent Jay often said, we know that time is your most valuable asset, and we appreciate you spending that asset right here with us. Ladies and germs, my name is Will Stevenson, but more importantly, you've been watching the Degen Roundtable, and I'm the producer, signing off. So I got to remember to remind you guys to remember to Degen responsibly. And let's see if this works. Oh, I have to click 2 buttons. There we go. All right, here we go. Degen responsibly, everybody. Eventually. Good golly. Look at me learning how to